My lord, may I have your lordship's leave to mention a matter, my lord,
Yes.
which appeal was disposed of on 10th May 2023 by your lordship's order, my lord. My lord, what was happened in the morning, this appeal was disposed of.
Hmm.
My lord, I have my lord, the executed the vokalatnama and competency, but the department is saying that since the my lord matter has been disposed of, you have to take leave to submit the vocal.
Leave granted.
My lord, I am deeply obliged.
Yes.
Lord, appellates, I am mentioning on the appellate side.
Hmm.
Lord, extremely urgent PIL. Yesterday in Egra, Lord, Purbo Midnapur,
Hmm.
there has been an explosion
Hmm.
in the blood factory or house of a local political leader of the ruling party. There has been a loss of life.
Hmm.
As per media report, 12 to 15 persons have died.
My goodness. Hmm.
Lord, it's a scheduled offense under NIA. But we have information that bodies are being, Lord, taken away.
Have you given notice to the
I can
response?
give notice immediately. Let me move it at 2 p.m. Lord. This is very urgent.
Tomorrow. Huh? You give notice today.
Lord, kindly allow me to file by tomorrow's date and short service.
Short
It will appear
service,
tomorrow
yes.
at the top. Lord,
Yes.
My lord,
Tomorrow it will come. It will come above our names. It will come on here. Above High Court of Kent.
My lord, this is a. May I mention, my lord,
Yes, sir.
in the appellate side matter? My lord, it's a matter of great urgency in view of the fact that I am facing the contempt application. And contempt is a hard.
The intra-court appeal.
Yes.
You please file it. Sir, no notice.
My lord, may I mention, my lord? So this is a public interest litigation, my lord, running as item number 78 in today's list, my lord.
117.
No, 78, my lord.
78.
78, my lord. So this is, my lord, pertaining to pending wages of NREG workers to the tune of rupees 1,700 crores, my lord. And no new work has been commissioned since last financial year. So there's a very bad situation in rural Bengal, my lord. People are committing suicide due to poverty.
2 days I was not available.
Yes, that's why, my lord, it could not be.
Otherwise, it would have reached.
Yes, my
let
lord.
us see
Kindly
tomorrow.
keep it at 2 p.m., my lord. It'll be
No,
great.
not today.
My lord, may I be permitted to?
Kindly.
No, we'll make a note of it. Item 78.
Yes, my lord.
Yes, we'll do something by
My lord,
evening.
My lord, if it can be kept like, high on the order tomorrow,
Yes,
my lord.
yes. We have made a note.
My lord, may I be permitted to pay for leave, my lord, to file an appeal, my lord, without certified copy, my lord, on the basis of the internet copy of the or judgment and order, my lord.
What is the urgent? What is the
Pursuant
urgent?
to the order of the honorable single bench, my lord, I was whipped out from my matrimonial house, my lord. I am now I am being restrained to enter into my matrimonial house, my lord.
But in a writ petition, that order was passed.
Yes, my lord. That was why I am praying for filing an appeal, my lord.
All right.
Lordship, may I mention original side matter for inclusion, Lordship?
Yes,
Lordship,
please.
May I permit to mention, my lord?
May I have the
May I permit to mention one urgent application, my lord? The court, read court, my lord, had passed a order, my lord, the directing, my lord, the CSC authority, my lord, to give the connection in favor of the petitioner in my premises, my lord. They have not connected with my premises. I submitted before the read court, my lord, to appoint any person to go and they have directed with the police help, my lord. With the police help, my lord, inspection. Inspection will be done with the police help, my lord. Because, my lord, they have not.
No. Please serve notice on the response.
Yes, my lord. I have already served all application to the all writ petitioner, including CSC. I will again serve, my lord, the copy of the application.
Because you should have served saying that you're going to mention.
This is the I served the notice. I mentioned Monday, my lord. So, my lord, Monday was not court was not. Again, I served, my lord.
All right. Once more, you serve.
My lord, may I have your lordship's kind leave to mention two anticipatory bail applications, my lord, which were filed before the circuit bench at Jalpaiguri. My lord, as
what you need to do is, as per the Jalpaiguri circuit bench rules, you need to make a request to the registrar there. Rule 5, I think. They will immediately forward it. I will assign them. That's the procedure. You please speak to OSD and he will advise you how to do it today itself.
Lordship, may I have your kind leave to mention upon notice to the other party, my lord? I have mentioned this in last 9th of May, but by mistake I forget to attach the notice served upon the opposite party.
What is the matter?
Matter is, my lord, one young contractor has been terminated illegally by the respondent, making him insolvent and bankrupt.
Please give.
My lord, if you kindly give it time tomorrow at any time, my lord.
You please give the mentioning slip. Let us see.
Okay.
Yes.
My lord, may I be allowed to mention a matter? There are few corrections in my lord's order. My lord.
It's original side matter.
Original side matter. My lord can fix it tomorrow in the to be mentioned.
To be mentioned. Yes.
My lord, grateful, my lord.
You give the number. Yes, sir, please come.
Original side daily list item number 1.
Please, Your Lordship, I am appearing on behalf of the appellant. I have been led by the learned Advocate General and Mr. T.M. Siddiqui. Mr. T.M. Siddiqui is engaged in some personal difficulty, having some personal difficulty. But kindly, if it can be fixed on Friday, my lord.
What is this under the caption to be mentioned?
My lord allowed the appeal since there was a contempt application pending.
Mr. Siddiqui is not available.
Today, my lord, he has some difficulty, my lord.
So after
He has, no, my lord, he has mentioned the matter, my lord, the contempt has been proceeding with. Here, my lord, very earnestly requested your lordship.
tomorrow. All right. At the request of the learned advocate for the appellant, list tomorrow.
Grateful, my lord.
For orders item number 2.
Details of case files deposit lying with RB without earning interest. What is this law? So direction has to be issued to keep it in an interest bearing. So this case file is not there. So that can be directed to be. Please. Totally item 2, 3 and 4.
In the office note, seen the note dated May 10, 2023 of the registrar original site. The department is directed to produce the records pertaining to the aforesaid matters as well as the order sheets or the minute book containing the orders passed in the aforesaid matters and the account details. Shall we keep it?
We give a date.
On the next date of hearing.
14th June.
List this matter under the same heading on June 14, 2023. The concerned court office, the concerned officer attached to this court is directed to communicate this order to the superintendent, to the registrar original site by tomorrow. Calculate date.
Yes.
Item number 5.
May it please your lordship. This is my application, but there is a mistake in the cost title of my recalling application. I have sought to my lord recall an order by which my lord my delay was dismissed and delay was not condoned. But my lord the cost title should have been my lord PRCIT 3 instead of my lord what is appearing in my application PRCIT Central 1. I have sought as per your lordship's direction to my learned friend, but with an erroneous cost title. May I be my lord granted a leave, my lord?
No, it says Haldia Petrochemical. No.
My lord.
What is the mistake in the
mistake is, well, the name of the applicant should be Principal Commissioner of Income Tax 3 instead of Principal Commissioner Central 1. That is, the wrong has appeared in the face of the application. My recalling application, my lord, is incorporating a wrong cost title.
No, it says Principal Commissioner of Income Tax 3.
my lord is looking at recalling application, which
Oh, in
my
the
lord is
recalling
taking up.
application, you've given a wrong cost
Yes, my
title.
lord. And that application
All
is,
right, what is the recalling application?
my lord, I have prayed for my lord recalling of the order by which your lordship had dismissed my condemnation of delay.
440 days delay.
440 days delay, my lord. If your lordship, my lord, kindly allow this.
This application has been filed after 402 days, 2 days of.
Oh, there's a delay in this.
My lord, if I could make, my lord,
The order was passed on the 15th of February 2022.
my lord,
Filed this
I-
in the month of March 2023.
I understand, my lord, the opposition taken out by my learned friend, but if I could say it like this, my lord, I have gone through the procedure limitations. My lord, recalling application, my lord, does not come within any of the schedule of
No,
the
no,
limitations.
all right, doesn't matter.
I have,
But
my lord,
still a reasonable time is there. Though you may not be required to file a section 5,
my lord,
but still this order was passed on 15th of February 2022.
my lord.
24th of March 2023, this application has been filed.
My lord, I have, my lord, explained in the body of my application without taking out any separate application to condone this delay, my lord. There are some difficulties, my lord, in taking out this decision of my lord, praying for this order to be recalled.
All right, sir.
So that can be, my lord, if your lordship, my lord, for the timing, my lord, setting aside this, my lord, technicalities of the matter, and my lord can fall back into the main issue, my lord, because, my lord, the delay in question was only a 440 days. I believe, my lord, I should not, my lord, I should not be saying this,
If
that
it
this
is
is
4
only.
days, at times we have to reject it. Sometimes even if it is 400 days, we can allow it.
My lord, there are occasions, my lord, where your lordship had, my lord, exercised that discretion, and my lord, I have allowed that
All
in
right,
favor
you
of
have
that.
heard. Please come. You have heard Mr. Tilak Mitrol and advocate, standing counsel appearing for the appellant department, and Mr. Ajay Gargar, learned advocate for the respondent assessee. It is submitted by the learned advocate for the applicant that in the cost title, the name of the applicant / appellant has been wrongly shown as Principal Commissioner of Income Tax, Central 1, Kolkata, instead of Principal Commissioner of Income Tax, 3, Kolkata.
Right.
This correction be carried out in the cost title.
Get.
This is the next paragraph. This application has been filed to recall the order dated 15th February 2022, by which GA number 1 of 2020 was dismissed. There was a delay of 440 days in filing the appeal. And on perusal of the condoned delay application, we found that there is absolutely no explanation for the inordinate delay. And the only explanation was that the files were moving from one table to another. Thus, we were not persuaded to exercise any discretion in favor of the applicant department. This application has been filed to recall the said order on 24th March 2023, more than 1 year after the order was passed. We find no justifiable reason to recall our earlier order. Accordingly, application is dismissed. Yes, next.
Item number 6.
I am defending this recalling application, my lord.
Same.
No, this is not my application.
This
My
is my
learned friend, my lord, has
application,
taken out an application for recalling
You
the
are
order.
not served in the matter.
Your lordship, I have served the
No.
reply.
Initially.
I was served, your lordship. It was my mistake as an advocate.
And on the last occasion, my lord, I have
Lordship,
taken out an opposition with regard to, my lord, this recalling application that has been taken on record, but my lord, if lordship kindly record that I have taken out the opposition.
Yes.
The lordship had missed to, my lord, mention that in the last order.
Your lordship, we
I've
have
taken
filed
out
that
an
reply.
opposition.
We have served the reply, your lordship. We have to file it. Your lordship, the only legal point which I'm arguing, because I have nothing on merits, your lordship. Because this is the LTCG matter, your lordship. The matter is, your lordship.
I need to go through
What
the
is the-
reply. I this is the reply.
I have served it.
On what ground do you want to recall the order?
Your lordship, what has happened is there was a delay of more than 1,000 days. If I were to if the court condones the delay, your lordship, it goes back to a date which is prior to the circular which allows them to file an appeal in a low tax effect in LTCG matters. So the argument, your lordship, that simple legal argument that I want to take, your lordship, is that if the court condones that delay, then in effect CBDT is asking for a retrospect, or the department is asking for a retrospective look for the circular which amends for LTCG matters.
Already you give a copy of your reply.
I have not received.
All right.
I'll come back.
we have heard so and so. On the last occasion, the learned standing counsel for the department had filed the affidavit in opposition to the recalling application. And on today, a reply has been filed, copy of which has been served on the learned standing counsel for the department, who seeks time to get instruction in the matter. List on immediately after.
Apart from, if I could only point out, apart from the point which my learned friend is taking, that is a procedural irregularities, because my lord, I would harp on this.
We will hear,
Get full.
give a date after vacation.
Thank you. Yes, sir. Go to record for a minute.
Item number 7, review
This is my
application.
Review application.
Hmm.
On last occasion, I heard my lordship, you had heard me. My review is only on this point that at the time of filing of the appeal, they had suppressed the fact that the refund had already been issued to me.
Hmm.
You had also passed an order, your lordship, on last occasion. And also placed a judgment, your lordship, on last occasion. Passed by you.
Yes, this is review application 11 of 23.
Your lordship, this is the order I relied on. My review application is 19 of 2023, item number 7.
Yes. What do you say? Sonal? They have implemented the order.
Lord, my school submission before your lordship, my lord. Lord, it is not the simplicity, my lord, that at the point of Lord passing the judgment, the my lord assessee did not, my lord, have the knowledge that the refund has been given. My lord, from the order itself, it cannot be said that, my lord, there is any error in the apparent from the, my lord, order. My lord, the principle, my lord, order 47 rule 1 is very clear in this regard, my lord.
But
Well,
then
well,
on the date when you file the appeal,
Let's
the order had
may I,
already-
may I. The my lord, the refund has been maybe given to the assessee. Thereafter, my lord, circular issued on my lord, September 2019. My lord, by virtue of that circular, department my lord, preferred the appeal before this honorable court. At the time of hearing the appeal, my lord, the point that the department my lord, refunded the money, that was in the knowledge of the my lord, assessee. He could not point it out. And my lord, in the face of the order, it cannot be said that my lord, in this matter, my lord, the Sati Bajaj branch, my lord, the Sati Bajaj branch, the order has been passed. In the several batch of matter, the order has been passed, my lord. Now, my lord, my respectful submission before lordship, my lord, there is no error from the apparent of record, my lord, for my lord, the review application.
Correct. On merits, there is nothing.
Nothing.
But on the date when you file the appeal, if the order of the tribunal had already been implemented, you could have said one thing. This order is being implemented without prejudice to the rights of the department to prefer an appeal against the judgment of the tribunal. If that disclaimer or that qualification was there, it's fine. Or you could have mentioned in the grounds saying that though this order has been implemented, refund has been granted, but yet we are going to challenge this order on 1, 2, 3 or X, Y, Z grounds.
My school submission before lordship, when the department, when the circular of 6 September 2019 has come, the department in the penny stock matter, in several penny stock matters, the taking the decision to file the 260 application.
All right. Have you filed your?
No, I kindly allow me to file opposition to the this review application.
There is a delay. No
A delay.
How many days?
283 days, your lordship. 76 years old lady, your lordship.
The other case
delay,
also
I-
76 years old lady.
Same,
Premlata Agarwal.
same lordship.
Not only that,
Lordship, my
not all-
submission is only on suppression, your lordship. You have
suppression by whom? Suppression by the assessee itself. the refund has been issued to
Lordship,
him.
it is
At
their
the
appeal.
point of time, when the matter has several times matter heard by your lordship, at
But,
that point of time, he could apprise the lordship.
You are not appearing in the
Yes, your
case.
lordship, I was not appearing.
So change of counsel is no ground to review.
No, but lordship, I'm only on suppression, your lordship.
No.
I have annexed their stay
No, no,
their
what
section
he-
5
no, no.
application.
Mr. Soman Bhattacharya has got a point. You are aware of it. So should you not have brought to the notice of the court that on the date when they are pursuing the appeal, the refund has already been granted, appeal was not maintainable. Now, by changing the advocate and saying that my earlier advocate.
Lordship, you have also considered other cases.
Not only that,
On the same point, your lordship.
one review, this honorable court.
What we can do is,
Kindly allow us to file one objection to the.
wait. We will uphold the order or we'll dismiss this review on merits.
Fine.
But we will say that in the light of the fact that refund has already been effected prior to the filing of the appeal, the department shall not recover the money.
That can be done, because
So you succeed either way.
because point of review, there is very limited scope.
That's the
Your
best
lordship,
option you can do.
your lordship also
You will
knows.
say that this was not
Lordship,
brought.
but my penalty is also there, your lordship, on the basis of this assessment.
That is an independent cause.
Lordship.
With this order, you challenge that penalty order.
Lordship, but kindly, you have passed similar orders. Your
No,
lordship. So many cases. I have placed
Because
this, your lordship.
I could not.
They are suppressing,
I
your
could
lordship. These
not
are material information.
I could
It
not
was very
download
lengthy,
the
your
order of
lordship.
this honorable court. Justice Bindal, and Justice Rahashri Bharadwaj, review application 2021 of 2021. Following the judgment of the honorable Supreme Court, it Kamalesh Bharma versus Mayawati. A judgment has been passed by this honorable court, rejecting the review application. The principle has been laid down. In that way, the review application cannot be allowed.
Lordships, I have also annexed their section 5 application. There is no utterance of this.
That is
And
closed.
also, your
That is
lordship,
closed.
We have heard so also. There is a delay of 283 days in filing this review application. Upon perusal of the averment set out in the application for condemnation of delay, we find sufficient cause has been shown for not preferring the review application within the period of limitation. Hence, the delay in filing the review application is condoned. Next, this review application has been filed to review the judgment and order dated 14th June 2022 in IT-80 number 138 of 2021. The said appeal filed by the revenue along with a batch of cases were heard on several dates, and by common judgment dated 14/6/2022, the appeals filed by the revenue were allowed and the substantial questions of law were answered in favor of the revenue. By this review application, the assessee seeks for recalling the said order on the ground that the order passed by the tribunal has been implemented and refund order dated 17/5/2019 was passed much prior to the department filing the appeal before this court. As rightly pointed out by the learned senior standing counsel for the revenue, this fact was not brought to the notice of this court when the appeals were heard, though the assessee was served and was represented by counsel. It appears that the counsel who was presently filed this review application was not appearing for the assessee when the appeals were heard. Therefore, on the said ground, we cannot entertain a review application. That too, to review a common judgment wherein the substantial questions of law were answered in favor of the revenue. However, considering the peculiar facts and circumstances and that the department has already implemented the order of the tribunal and refund was effected to the assessee, we find that that the said amount which has already been refunded to the assessee should not be recovered by the department on account of the judgment dated 14/6/2022. With the above clarification, the review application stands disposed of.
Lordship, service be kept on record, service.
Affidavit of service kept on record. Two matters,
Next one, same, your Lordship.
7 and 8. Same same number of days? delay?
No, 299 days, your Lordship, in the
Second one is
second, item number 8.
Next.
Deeply grateful, your Lordship.
Item number 9,
I'm the
application adjourned.
I'm the last respondent, my lord. I have been served with an affidavit in opposition day before yesterday, my lord. I will take out and reply to that.
How many days delay?
1,200 days.
266 days.
But the assessee is a very big assessee.
Yes. Very big.
Well, as
assessment.
factually, man, this is basically, there is no question of law involved, my lord.
I will apprise.
Current
I will
finding of
apprise on
fact
that.
by the CIT appeal and
So
the
let me take
tribunal.
out and reply to
was
that.
only-
And let me come back.
Man, kindly,
Quantification of wastage. But cessation of liability is not automatic.
But my lord, I shall argue on this, but I believe, my lord, at this stage, my lord, let me take out and reply with regard to, my lord, the
Fine.
opposition.
has
Fine,
not been
fine.
raised in the question of law.
That is not.
But CIT appeals has done a very thorough factual examination and rightly relied upon that Kesari tea
Yes, madam.
and that Sugali sugars,
Page 30 is the observation.
236 ITR. And this is a scheme where the customers
Yes.
make monthly payment.
Yes, madam.
That is,
Every jewelry has floated the same scheme, my lord. Not only this jewelry has been. This is a regular practice of the company.
But these advances may get adjusted at a subsequent date as per the scheme.
my lord,
It may be 120 days, 3 months, 4 months, or 6 months.
that is permissible, man.
1,266 days,
Yes.
23 lakhs is the
I may
amount.
not, I don't think that I'll be able to, my lord, improve much on that, but still, my lord, let me take out and reply, my lord, and let me try to, my lord, apprise your lordship on that score itself first of all. I understand my learned friend is, my lord, opposing me with regard to that and have, my lord, served me opposition day before yesterday. So, my lord,
What has he said in his opposition? You can't improve upon.
There is no explanation from 9th of.
It's more than 3 years.
Yes, madam. And there is no explanation from 9th of March 2022 to 15th March 2023. There is no explanation at all.
Oh, what date? 9th of?
9th of March 2022 to March 15, 2023. There is no explanation.
Three years is too long a period.
page para 21 of the application.
All right, please come. This application has been filed by the revenue to condone the delay of 1,266 days in filing this appeal. The order impugned in this appeal was passed by the tribunal on 3rd May 2019. And copy of which has been received by the department on 31st May 2019. And the appeal ought to have been filed not later than 28 September 2019, but was filed only on 17th March 2023 in the 23 after a delay of more than 3 years. On perusal of the affidavit filed in support of the condoned delay application, we find that the department seeks to take advantage of the order passed by the Honorable Supreme Court, extending the period of limitation for filing appeals under various statutes on account of the COVID pandemic. This decision of the Honorable Supreme Court cannot lend any support to the department, as the period for filing the appeal within the period of limitation expired on 28 September 2019. Apart from that, we find there is absolutely no explanation for the delay from 9th March 2022 to 15th March 2023. Thus, the delay being inordinate and unexplained, we are not persuaded to exercise any discretion in favor of the department. Accordingly, the application is dismissed. Consequently, the appeal stands rejected, and the substantial questions of law suggested by the revenue are left open.
My only difficulties was that I could not point out because there are certain things because this file was kept with the advocate who could not do this, but I cannot go against the bar because I feel when this is also
better leave it at that.
That's why I'm not pressing that thing.
Item number 10, public interest litigation.
I'm for the Union of India.
But on the last occasion, state for time.
What is this public interest litigation?
The issue was the first appellate authority. The person,
yes,
the person responsible first appellate authority must be the law graduate. Background must be a legal.
And who will appear for the state?
On the last occasion, he prayed for time for instruction.
Because today they are not. Yes. Sisanya Bandopati and A.K. Nag. Where are they today? And this, who are the respondents?
But I beg to the second appellate authority, West Bengal Information Commission, Lordship.
There is some allegation.
I'm for the respondent number 1, Miller, Union of India.
Union of India. You are for the Secretary, Ministry of Law, Government of West Bengal.
I'm for the West Bengal Information Commission. That is respondent number, Lordship.
4.
Yes, Lordship. 4 and 5.
And what is your instruction?
Well, so far as the notification is under challenge, that is enacted by the notification issued by the state government.
They have to answer.
Yeah.
And there is some allegation against them also, respondent number 4 and 5, because there is a large number of cases pending under the RTI in respect of second appeal and complaint year after year. Though there is a statutory period 30 days and not more than 45 days. And if there is a delay, there must be some reason recorded in the order itself. They are not complying with me. There is a specific complaint against them. I have enclosed some appeal and complaint also that is still pending. That should be regularized.
Lord, first of all, Lord, this is a separate cause of action altogether. Lord, all these different causes of action cannot
But
be.
this is a larger issue.
A larger issue, right, my lord? But so far as the second appellate authority is concerned, my client, that is West Bengal Information Commission, statute doesn't provide any time limit for us.
Yes, no, not at all.
No, that's a different matter.
Yes.
See, if you restrict your challenge to the notification regarding the appellate authority for Gram Panchayat.
Yes.
That alone you please restrict.
That was the moot issue on the last occasion also.
Then you serve notice once more. You can serve notice. We have heard so the learned so and so. Though on the last occasion, the state was represented by the learned advocate. Today there is none appearing for the state. The learned advocate for the petitioner is directed to serve the learned, the concerned learned advocate who appeared for the state, let the matter immediately after vacation.
Seventh.
All right, let the matter appear on 7th June.
7th June.
Yes.
But kindly observe that these public interest litigation
That
should be restricted to that.
In the presence of the,
Grateful, Lordship.
yes.
For admission, item number 11.
7 and
I am representing High Court.
I am for this appellant, my lord, this is today's your date fixed for, my lord, admission of the appeal. My lord, the relevant portion I may draw your kind attention, that is under challenge before your lordship, that is page number 11 of the order impugned. The page number 11, paragraph 45.
But according to you, this document was in the custody of the court.
My lord, there is a contradictory view. The persons of the court responsible, they are saying the documents is laying with the police. Police is saying the documents is laying with the court.
Now
I have made party all of them, court as well as the police.
Now this in the civil litigation, you have lost right through.
Yes, because we cannot produce the documents.
Then such a prayer could have been made in the civil proceedings itself. And after having all avenues shut, suddenly this is a tortious. This is a tortious claim. You sue for compensation. We have to fix responsibility. How to do it in a writ petition?
Lord, kindly come to page number 9 of para 35. I have previously filed a writ petition, and that writ petition I have been given liberty to pursue in the matter after getting the certified copy, and the kept open for compensation issue.
No, nobody is disputing that. Only thing is, before which forum you should
decide. Which Lord, after about 25 years, Lord, today I go for
let us see that observation.
Yes,
by the writ court.
Yes, Lord, the relevant portion, Lord, in my supplementary affidavit. Supplementary affidavit to dinner. That is.
The page number 47.
Yes, my lord.
The court says.
Since the petitioner is in middle portion, my lord, third paragraph. Since the petitioner in law is now in position to lead secondary evidence in support of his claim before the adjudicating authorities, the claim for the compensation need not be assessed at this stage. And prior to that paragraph, my lord, since the state is making over photocopy.
So therefore, this liberty or whatever observation was made keeps open, because the writ court did not assess the compensation. So you can't file a writ petition. Suppose it is a case of some police excess or any other problem, like the drainage was open, the boy was going, or some negligent act of the state. But this is a factual matter which needs to be established, pleaded and proved, and you have to fix responsibility. That can't be done in a writ petition.
Lord, the point is this, my lord. The document seized and the amount covered therein, that is admitted fact. That is admitted fact. It is not the disputed. That is admitted fact. Will not kindly. If
Now,
your
now,
lordship
now that you have got a certified copy of the seized document,
Yes.
you were allowed to proceed further, but unfortunately you were unsuccessful in the civil proceedings, which came up to the stage of appeal.
What happened? In 2012, my suit was dismissed, and 2018, I got the copy of this from the police authority after 6
Then
years.
your limitation for filing the
Review application gone, has not been allowed. Challenging that order, I filed the revision application. That is also not entertained because there is no illegality in
and thereafter you will start a claim for
No,
compensation.
prior to that, I have filed. In 2013, I have filed the first edit petition prior to review.
Correct. 2013, the court did not assess the
Yes, because
compensation.
at that point of time, handed over the certificate copy by the state.
You got the certificate copy,
Yes.
you proceeded.
Yes.
And this judgment was passed in the year 2018.
Yes.
You could have immediately either filed an appeal against this order, saying that, no, issuing a certificate copy is fine, but still I need to be compensated. Or you could have filed a suit for compensation, claiming compensation.
No, my lord, there is a specific amendment. Kindly consider. Since the state is making over the photocopies of the documents seized by the police authorities today.
So your
and since kindly consider this, and since the state certifies them to be the exact photocopies of the documents seized, it would be open to the petitioner to produce such documents before the appropriate authority in accordance with law.
True.
That means at that point of time, I have tendered before the civil court for accepting as a secondary evidence.
That's a different matter. Suppose you were aggrieved by that portion of the order passed by the learned single bench, saying that we will not assess the compensation. You could have done two things. You could have filed an intra-court appeal against this order, against that portion of the.
Yes.
Or you could have filed a suit for compensation soon after to save limitation. Now what to do in 2023? And that's why in fact, very strong observations have been made by the court saying that you have come with unclean hands.
No, but that is, I think, some misunderstanding according to the interpretation of the order itself, my lord. Because it is, I want some time, my lord. I want to place some decision because the decision I have placed before the learned single that has not been properly appreciated. My lord, appeal be admitted and fix up hearing after vacation, my lord, kindly.
For admission, you have to make out a prima facie case.
No, my lord, it will take some
And
time. Otherwise,
you relied upon 2002 SEC online. This P. Viswanathan versus Dr.
That is not applicable at all because in a completely different aspect.
That
My
was-
case is completely different.
That was relied upon by High Court administration, my lord, to show that, my lord, this writ petition is not maintainable.
But that is not my case. My case is completely.
Even now, it is not too late. You approach the appropriate forum. We will grant that liberty. You file a suit for compensation. There are a lot of avenues. You are now before a wrong forum. So that liberty has not been given by
There
the
is
court.
some decision of the Honorable Supreme Court. But if the proceedings is already covered in a long period, thereafter again I go for the civil suit, it will again another 20 years. My lord, by this time the appellate will not be in the earth, my lord, because he is already 60 years old. And he is fighting for the last 25 years in the civil court. Now again he will go for another
And
20 years.
unfortunately, he was not successful.
I know the civil court is the proper forum, but some exceptional circumstances, Supreme Court says the writ petition is also maintainable for awarding the compensation. Kindly consider my cited decision. Whatever I have cited before the learned single judge. Kindly consider this.
Court says, none else but the petitioner is to blame for the considerable delay of more than 1,300 days in filing the review application. After losing in the review application and in the revisional court, petitioner also lost his appeal against dismissal of suit only on the ground of non-payment of court fee, which could be attributed only to the petitioner. Such laches are merely being sought to be covered up now by filing the present writ petition for compensation against the respondent. As much as judgments cited are concerned, none of them so. Please come. We have heard so and so. This intra-court appeal by the writ petitioner is directed against the order dated judgment and order dated 11th August 2022 in WPO 831 of 2021. The said writ petition was filed by the appellant claiming compensation for loss of a document which was supposed to be in the custody of the court. Earlier, the appellant had approached this court and filed a writ petition. And a direction was issued in the said writ petition A direction was issued in the said writ petition to furnish a certified copy of the said document so as to enable the appellant to pursue his remedies before the civil court. It appears that
Authority.
In WP number 31667 within bracket W of 2013 dated 26/6/2018. In the prayer sought for in the writ petition was to grant compensation by the state on the ground of loss of documents seized by the police authorities with regard to a complaint lodged under section 138 of the Negotiable Instruments Act, 1881. The court by the said order directed certified copy of the document to be furnished to the appellant and did not assess the claim for compensation. Thus, the writ petition stood disposed of only with the direction to furnish certified copy of the said document. The appellant allowed the said order passed in the writ petition dated 26/6/2019 to attain finality and kept pursuing his remedy before the civil court, which ultimately was dismissed and confirmed by this court in revision. Thereafter, the present attempt has been made by the appellant seeking for compensation. In as much as the said compensation was not assessed at the when the earlier writ petition was disposed of, the appellant has chosen a wrong forum for claiming compensation. Full stop. As rightly held by the learned single bench, the issue raised by the appellant involves disputed questions of fact, which obviously cannot be adjudicated in writ petition. Thus, we find no grounds to interfere with the order passed by the learned single bench, and accordingly, the appeal is dismissed. However, it will be well open to the appellant to pursue other remedies available under law, if so advised, before the appropriate forum. Next, dismissal.
Item number 12.
Yes.
Or back to appear on behalf of the appellant's mind. The respondent has imported raw petroleum coke. Or there was intelligence which suggested that the raw petroleum coke contains sulfur content which is more than 7%, which is not permissible. Therefore, my lord, the goods were seized, samples were drawn up, samples were sent for testing. The test results suggested that the sulfur content is more than 7%. My lord, they made an application for provisional release for the said goods. The said application was thereafter, my lord, they preferred a writ petition before this Hon'ble Court. The Hon'ble Writ Court directed the application for provisional release to be considered. Challenging that, my lord, they preferred an appeal before this Hon'ble Court. The appeal came up for hearing before your lordships, and upon hearing, your lordships directed that the provisional application is to be heard out. Along with that, adjudication proceeding will go on. My lord, the authority concerned disposed of the said application for provisional release, negating the prayer of the provision for my lord, clearance by provisional release. Challenging that, my lord, an appeal was preferred before the learned appellate authority. Appellate authority directed that the goods be released provisionally. Challenging that, the department preferred an appeal before the Hon'ble Tribunal. Hon'ble Tribunal, my lord, rejected the appeal filed by the department, and against that order, I am before your lordship. These are the facts of the case, different proceeding which has already held.
Now you please show the
Yes.
order.
Now, lordship kindly comes to the license that has been issued in favor of the writ petitioner respondents. Lordship, may I just read the license, the terms of the license? This should be in the compilation copy. Yes, sir. Lordship, may I hand over a copy of the compilation where the license is there? Lordship, kindly comes to page 7 and page 8. The license is there. The license issued by DGFT.
No, I think it's Mr. Sudhir Mehta.
Yes, yes.
I had marked it
And only one or two pages, but my lord, ignore it.
No problem.
I will be only showing the license, nothing more.
Page number?
Lordship kindly comes to page 7 and page 8.
Yes. Import license for
Yes,
restricted items.
Now Lordship kindly comes to page 8.
This I did
Details
for
of-
convenience of my friend, my lord.
I'm thankful to my learned senior friend. Details of items sought to be imported under the license for restricted imports. Lordship kindly sees on the top ITCHS is shown as 27131110.
Yes.
The product is petroleum coke, raw petroleum coke for anode making in aluminum industry conforming to standard IS 17049.
Correct.
So the license categorically says that it has been issued for the purpose of importation of RPC, that is raw petroleum coke, for the purpose of anode making for the aluminum industry, and it should mandatorily conform to the standard IS 17049. So by all means, this standard or these restrictions or these conditions or stipulations, what has been mentioned in the license has to be maintained.
Yes.
Now Lordship kindly comes to the IS standard. Lordship kindly takes up part 1 of my stay application.
Yes.
At page 35.
Yes.
This is the page 35, the relevant IS standard starts. And the relevant portion is at page 38. Lordship, on the top, your Lordships will find that IS 17049-2018 is mentioned.
Yes.
On the top left-hand side. Now, Lordship kindly takes the table, table 1. Requirements for raw and calcined petroleum coke for anode making in aluminum industries. Now, Lordship kindly comes to the serial number 8, Roman 8.
Total sulfur percent.
Total sulfur percent by mass. For RPC, that is raw petroleum coke, it is 4%. And for CPC, it is 3.5%. The next column, that is for CPC. We are concerned with RPC only. Now, Lordship kindly takes the footnote. Note, based on the availability of RPC with varying sulfur content, RPC with sulfur content more than 7% is not permitted for making RPC of sulfur content 4% maximum. Therefore, my lord, the maximum sulfur content that is permissible in RPC is 4%. More than 4%, it is not permissible. Now, Lordship kindly comes to the notification issued by the DGFT in this regard. Lordship kindly comes to page 44, the relevant portion at page 50. Page 44.
Yes.
Lordship kindly comes to page 45 once. I will show the headings of the different columns. Item description, policy, page 45.
Yes.
First is the exim code, then comes the item description, then comes the policy, then comes policy conditions.
Yes.
Now, Lordship kindly comes to page 50. The last entry. This is the CTH which he has imported. That is RPC under the license. Now, Lordship kindly sees raw petroleum coke for anode making in aluminum industry conforming to standard IS 17049. And the goods are prohibited. But there is a window. Window is as per policy condition number 6 of chapter 27. That is the chart that I've shown to you, Lordship. Okay. It should be 4%. So the import is restricted, but overall it's prohibited. Lordship, the chart is at page 38.
Yes.
The total sulfur content percent by mass is 4% only. If it is 4%, then it is permissible as per the IS standard and as per the notification issued by the DGFT. Therefore, my lord, I humbly submit at the cost of prolixity that 2 conditions are very important. That he must import it complying with the IS standard and complying with the notifications. Over here in the instant case, my lord, the importation has been done. The test results suggest that the sulfur content is more than 4%. The sulfur content is exactly more than 7% as per the test results. Therefore, these goods are prohibited. Now, Lordship kindly sees that as per section 233 of the Customs Act, it defines what is a prohibited goods. Customs Act. May I read it for your Lordship's convenience?
Yes, please.
2 subsection 33 prohibited goods. Means any goods, the import or export of which is subject to any prohibition under this act or any other law for the time being in force, but does not include any such goods in respect of which the conditions subject to which the goods are permitted to be imported or exported have been complied with. Therefore, if certain conditions have been laid down for importation, that conditions have to be strictly followed. Over here, the conditions have not been strictly followed. This is my humble submission. Therefore, these goods comes under the category of prohibited goods.
Now, on what ground the commissioner appeals?
The commissioner appeals has not considered the imported goods. My lord, when the test is to be applied, the test is to be applied is whether the goods which have been imported are complying with the conditions as provided in the statute or as per the notification or as per the provisions of law. The learned first authority, that is the commissioner, has held that the end product complies with the conditions or the requirements. And he comes to the conclusion on the basis of the certificate issued by the CA. Now, Lord,
the end product means
the end product as per the Commissioner of Customs is CPC. But over here from the Lordship, I have shown to your Lordship the license. The license says the license has been granted only for the purpose of anode making in aluminum industry.
Correct.
And the learned first appellate forum says that they are calciners, and they have the finished product that they have made is CPC, that is calcined petroleum coke. Whether they make calcined petroleum coke or some other material, that is not the concern of the learned first authority. The concern of the learned authority should be RPC, whether the RPC that has been imported by the importer complies with the conditions or the stipulations of the license as well as the stipulations as stipulated by the IS.
Since they are calciner, it is not applicable to them. Restriction is not.
Lordship kindly comes to page 101.
The discussion starts from 91.
Yes, my lord. The order starts from page. The order starts from page 101. If your Lordship kindly comes to the order passed by the first appellate authority. Lordship kindly comes to page 114, the relevant portion which the learned authority has. Yes. These are the reasons passed by the learned first authority. Lordship kindly takes up paragraph 14, the second paragraph of paragraph 14. In the instant case, the importer is not any aluminium industry, but is a calciner and uses the impugned goods or imported RPC for producing CPC. The efforts, sir, page 114. In the instant case, the importer is not any aluminium industry, but is a calciner and uses the impugned goods imported RPC for producing CPC. Well, this is contrary to or in violation of the license that has been issued in favor of the importer. The license says that that it should be used for anode making for aluminium industry. The aforesaid Indian standard only prescribes the requirement for raw and calcined petroleum coke for anode making in aluminium industries, not prescribes any of the specifications for requirement for producing CPC from RPC by a calciner. Therefore, my lord, the end product is not the subject matter of concern for any of the authorities concerned. The subject matter for concern for any of the authority concerned is the first product or the imported product. Now, Lordship kindly comes to page 115 once.
Yes.
It is apparent from the above that aforesaid requirements are prescribed for RPC and CPC for anode making in aluminium industries and not for the calciner. It is further apparent that footnote to the table is also applicable to making RPC from RPC. No specifications or criteria is prescribed for manufacturing CPC from RPC by the calciner. Thus, I hold that the adjudicating authority has erred in interpreting the provisions of the aforesaid IS 17049. 2018. I humbly submit, one of the first appellate authority has erred in interpreting the said IS standard. IS standard is very clear that when a importer is importing RPC, the compliance should be less than 4% per mass of sulfur content in the said product. And it is not their case that they are importing CPC. It is their case that they are importing RPC. Now, Lordship kindly comes to page 118. The final finding made by the learned appellate authority. Paragraph 18. I further find the aforesaid IS standard is prescribed for requirement for RPC and CPC in anode making in aluminium industry. However, the appellant is a calciner and used the imported RPC as feedstock for making CPC from RPC for their customers with sulfur content ranging from 0.8% to 3.5%. I also find from the chartered accountant certificate, this is very interesting, Lordship. I also find from the chartered accountant certificate that the appellant has sell CPC having sulfur content ranging from 1% to 3%. Moreover, as per BIS, CPC for making anode in aluminum industry should have sulfur less than 3.5%, which the appellant complied with, and there is no dispute on this score. The learned appellate authority has diverted from the main issue. The main issue was whether the sulfur content was within the permissible limit as prescribed by law.
But there is some Supreme Court decision he refers
So
to.
that is in the case of MC Mehta case. Subject to correction, the MC Mehta case does not deal on this issue.
All right, then before the tribunal, what happened?
Now, Lordship, we challenged this and we went before the Honorable Tribunal. Before the Lordship, I further humbly submit that in the imported document, it is also reflected that the sulfur content is more than 7%, and they have admitted the same in their statement under section 108 also. Now, Lordship kindly comes to the order passed by the learned
147
tribunal. It is at page 147. It's a common order in respect of this matter and also in respect of the next matter. Lordship, the learned tribunal did not consider any of the contentions of the department or the appellant, and straightway makes, Lordship kindly comes to page 155. And the learned tribunal straightway comes to its finding without giving any independent finding or without giving any independent reasons. Lordship kindly takes up paragraph 8 at page 155.
Yes.
7 থেকে পড়াবেন ভালো হতো না presented 7
Lordship kindly takes up paragraph 7. The contention of the learned authorized representatives for the department is that the coal imported by the respondent having sulfur content beyond the prescribed limit, therefore the same is prohibited goods. Therefore, the impugned orders are required to be set aside. This is our contention before the main core contention before the learned tribunal. On the other hand, the learned counsel for the respondent submits that the respondents are calciner and use the imported RPC for making CPC from RPC for their customers with sulfur content ranging from 0.8% to 3.5%. As per the GIS, CPC for anode making sulfur content need to be less than 3.5%, which the respondent has complied with, and to that, the aspect has not been disputed by the revenue. Therefore, the appeals deserves no merit. Hence, we rejected the orders of release be issued as respondents are suffering demurrage charges. Heard the parties and consider the submissions in details. We find that the sole contention of the revenue against the provisional release of the impugned goods is that the said goods having sulfur content more than 4% and the same cannot be used by aluminium manufacturing industry. But revenue has not disputed the fact that the respondents are calciner and use the impugned goods as feedstock for making CPC from RPC for their customers with sulfur content ranging from 0.8% to 3.5%. But again, my lord, I humbly submit that the test applied by the learned tribunal is faulty, because the learned tribunal has applied the test in respect of the finished product or the end product, not in respect of the imported products.
Yes, Mr. Mathur.
My lord, only two things, my lord, I will have to comment.
Actually, the question would be whether the license condition has been satisfied.
yes my lord.
End product may be something.
Yes, my lord.
You may manufacture an environmentally friendly product,
Yes, yes.
but if the license says that it should conform to standard IS 17049, that should be the test. Can you put the cart before the horse?
No, no, not at all. My learned friend read only part of the matter and really covered one side of the moon and left it the other side.
No, no, you
My
please
lord,
cover the other
come to
side.
The
of it.
order of the Commissioner Appeal, tribunal's order, my lord. This page 147, which my learned friend read, page 147. Page 148 is the where the order of the tribunal starts, my lord. Regarding import of raw petroleum coke, a public interest litigation was filed in the Honorable Supreme Court. But may I read from my compilation? Because in that case, I will be referring to some other documents also, which I have enclosed it for this purpose, my lord. So if my lord, kindly from my compilation at page 138.
Yes.
At
So,
page
no,
140.
it is not in dispute.
But what I was submitting is.
Supreme Court accepted that the report of the Environmental Protection Committee or whatever it is, to permit import of RPC as calciners use as RPC, not as a fuel, but as a feedstock.
Feedstock. I use as a feedstock, and for the and what happens is this, that I was granted license pursuant to the order passed by the Supreme Court. What happened was this, prior to the Supreme Court.
But all these issues were
These are
not
there.
considered by the tribunal at
But
all.
this is my land friend not read it. My land friend.
No. The contentions may be there. Ultimately, the discussion says there is no harm. That's the language. The tribunal can't say that there is no harm. Who are they to say that? You please see that page number 156, 157.
156,
157. In that circumstances, we hold that there is no harm to release the goods provisionally. Who are they to say that? The scope is only restricted to now JDFT, DGFT has granted you a license.
Yes, madam.
You may be a calciner. You may be a calciner, but the license condition says that for what purpose you have imported, technical specification, details of the items sought to be imported under license for restricted import. Admittedly, it's a prohibited item.
Yes, madam.
It's a prohibited item. Supreme Court accepts the report of the committee with regard to calciners.
Yes, madam.
Because there is a fundamental difference using that as a raw material and a feedstock.
Yes, madam.
So that is why this percentage has been mentioned.
Yeah, but percentage is mentioned. That is, and I qualify. What my learned friend did is this: he read only half of the matter.
You read the
and
full
left
matter.
It, yes, madam. So let me give the full perspective of the matter, madam. If kindly.
So that means it's a case where the appeal has to be admitted.
No, madam. For this, madam, this is an appeal from order of a provisional release. Whether
you get the license amended.
My lord.
You get the license amended because how do we go behind the condition?
Yes, madam.
Raw petroleum coke for anode making.
Yes.
In aluminum industry conforming to standard IS 17.
This is to be read in context of the order of the Supreme Court under which this license has been issued.
That exercise the tribunal has not done. Then we send it back to the tribunal. Let the tribunal redecide the matter.
No, I'm not on that. I'm not on that.
No, you are trying to fill up gaps. We will not allow that to happen. We are on a question of law.
Yes, my lord.
If there is a question of law to be admitted, so where is that question?
It is at page 18 of my appeal.
No. Not 18.
Page 30 of the stay petition,
Number
30.
Page number 30 as well as page 18 of a memo of appeal.
So if suppose the tribunal has taken up this issue for consideration and said yes, no, the license has to be read in conjunction with the observations of the Honorable Supreme Court, and Supreme Court said for calciners there is a different yardstick. So though I might have imported raw material, but the license doesn't say that it is for a proper as a calciner. It is for manufacture.
My lord, you kindly see the license itself. It will be clear from the license itself. My lord, you kindly see the license at page 7. Condition sheet. Well, may I take 15 minutes, my lord, and I will clarify the situation because my learned friend did.
No, we will admit it and we.
This can't be admitted because this is an appeal arising out of a provisional order of a release.
Maybe, but then it is.
Whether a provisional order of release can give a substantive question of law.
Tribunal has abdicated its power.
Tribunal.
Say the least.
May just show this, my lord, this. Whether page 8, my lord, has got to come to page 8.
Please.
Condition sheet. The license is issued with actual user condition beside the usual condition of import authorization. The license is issued subject to the conditions prescribed in the meeting minutes of the meeting to finalize the import quantum of calcined cape at cape and it's the raw petroleum coke, which is uploaded in the GFT website, my lord. Here, when this license was given, my lord, kindly come to this page 9 with the Supreme Court order. And at the, my lord, we kindly come at page 12. Page 12 of this, of my compilation. To use of anode grade pet coke for CPC manufacturing. I am one of the party here. Then, my lord, you kindly come to the page 13. These applications have been filed by several entities, and CPCB have given a report dated 4th October in which it is stated as follows. The raw petroleum coke is a feedstock for producing calcined petroleum coke, which is a raw material for anode making in aluminum industry. I am pausing it here. The Supreme, I have a copy of the minutes downloaded where they say we are distributing the quantum total on the basis of this order passed by the Supreme Court. It says raw petroleum coke is a feedstock for producing calcined petroleum coke, which is a raw material for anode making in aluminum industry. So I'm allowed to import this quota for the purpose of anode making in aluminum industry. That is for what purpose license has been granted to me. Therefore, calcination of raw petroleum coke is a prerequisite to produce anode grade calcined petrol coke having sulfur content less than 3.5%. So the prerequisite to pursue anode grade calcined having sulfur content less than 3. But this paragraph 1, now I read paragraph 2, I will come back to paragraph 1. As per BI's guideline, calciners are permitted to use high sulfur containing raw petroleum coke for making CPC having sulfur content less than 3.5%. There still will be emission of S02 in high concentration para 1, which needs to be treated in flue gas desulfurization system having efficiency of sulfur remover more than 90%. The view expressed by CPCB have been considered by the Ministry of Environment, Forest and Climate Change, which is in the agreement with CPCB. It is stated by the learned amicus curiae that the view expressed by CPC are also acceptable to ECPBA. Consequently, raw petroleum coke, domestic and imported, can be used as a feedstock for producing calcined petroleum coke. We make it clear that raw petroleum coke for this purpose shall not exceed 1, etc. per in the total of this. Then, my lord, I come back on 1. My learned friend read that table 1 and said that whether I qualified for the purpose of 1. My lord, we kindly come to the table 1 again. That is at page, at my compilation, my lord will get it at
in this compilation, page 30.
In my compilation also it is there, and
So page 30, page 30 in my stay application.
38 of the step.
My lord may see from his copy 38, page 38. It is also there in my copy.
Oh, yes, sir. Yes.
Then this IS specification 37, page 37 of this application, which my learned friend read table 1, requirement for raw petroleum coke for anode making in aluminum industry. I was allowed to import raw petroleum coke for, now my lord, we kindly see my license for what it is being, what purpose it is being given, and for what condition it is being given. It is given for the purpose of anode making in aluminum industry, conforming to IS 17049. So if I am making something which is making it in terms of the license, which means that I am to use it only for the purpose of anode making in aluminum industry, conforming to IS 17049. Now my learned friend says that I've been finished. This is the finished goods. I'm asked by the Supreme Court that I will be manufacturing this and my products I should be allowed to import for the purpose of this kind of a finished product for which the specification is given. I manufacture that, I fulfill that. And when I fulfill that, then what my learned friend read is really putting a cart before the horse. He says, my condition which I am to meet should be in the condition of my import. It is something which is this.
Obviously, sir.
What I'm saying
No,
is,
it's a prohibited item.
no, it is
And
not.
you get
For
your
me, it
license.
is not prohibited because the
No,
license.
no, it says for anode making in aluminum. It doesn't, nowhere it mentions that you are a calciner.
It is there, my lord. It is there. It is, may I complete it?
No,
May I complete? It is there.
no,
my lord.
all this, the tribunal should make such
My
an
lord,
exercise.
I can go to the tribunal's order also. It is not
All
being
right,
read.
sir, we have heard you, sir.
My lord,
We will admit
what
the
I'm submitting is this, 2 minutes more, my lord.
No,
2
no.
minutes more. That almost only 40 metric tons are lying at the port out of 10,000. I have been importing these goods here, my lord. It is
Maybe.
not that these goods are
What
not
to do?
being
Only
allowed.
this time you are caught.
But these goods are being allowed to, these goods are imported on a
Let
regular
the
basis.
tribunal say,
On a regular
let
basis.
the tribunal interpret the license condition, weigh the observations of the Supreme Court and reject their application.
Well, the Supreme Court has dealt with the observation in the order.
Supreme Court, it is in a public interest litigation where all these hazardous substances, the import of which is being monitored. Why do they have a cap of not more than 14 ton? It's just now you read the Supreme Court.
Yes,
Where is that judgment?
I am within that. But one of the kindly say this that if I just give this.
Where is that Supreme Court judgment, sir?
I just give my lord the
13.
that
There is some significance for the quantity.
my lord, significance of quality is there. My
No,
lord, kindly
you read subpara 2 at page 13. What is the effect of SO2? Sulfur dioxide, high concentration.
Yes.
It will result in acid rain.
Yes, my lord, what?
You are accepting.
My lord, I am.
That is why this is very important. It says there will still be emission of sulfur dioxide in high concentration, which needs to be treated in the fuel gas desulfurization system, having efficiency of sulfur removal more than 90%. You can never remove 100%.
No.
And have you seen these factories? Is the chimney there?
Yes, chimney. Yes, my lord, what is there?
It's in touch with the atmospheric air at that level.
My lord,
every chance. So therefore, they ignite it.
My lord, the license, my lord, has shown it. But that minutes which was so mentioned, here are the minutes, my lord, of that. On which is I. No, my lord, one thing, my lord. I have one point, my lord. This point I could not make it, in fact. That this appeal was arising out of a provisional order of release, which does not make any dent so far. So far, my lord, the issues, legal issues are concerned. Legal issues are concerned.
No way. We will not go. We are not sitting on appeal as against the commissioner's order. We are sitting on appeal as against the order passed by the tribunal to examine whether there is a substantial question of law. We can admit this appeal only on ground G, that it is perverse.
My lord, whether a question, there can be a question of a substantial from an alternative arrangement. But
Definitely.
Arrangement.
Yes, sir, this is a hazardous substance.
But what I am submitting is this.
Then why should Supreme Court monitor?
Kindly see one document. That's all I want. So I won't take more than this after this. But this is one. This is with condition for which under license was given to me and allotted. This is minutes of the meeting of 9th March 22, etc. to import calcined petroleum coke for aluminum industry, raw petroleum coke, under which this license was issued. Paragraph 2. At the outset, committee noted that pursuant to the public notice number, this application were received for import of calcined petroleum coke. 22 applicants of raw petroleum coke. Committee noted that Honorable Supreme Court in a writ number, this is what we refer to, or has decreed that the import of CPC for aluminum industry cannot import aluminum. Similarly, import of RPC for CPC manufacturing cannot exceed 1 lakh metric ton. Accordingly, committee decides to make final allocation of etc. the quantity. Then, my lord, kindly come to page 7, page 18, where my quota is being given in this. My quota is given at page 18, where a limited quota was given on the basis of
Serial number 9.
Yes, this is 9. And this was subject to conditions. And the subject to condition was that where it was given that paragraph 9, that this license was given to applicant who have been allocated, paragraph 9.
Sir,
Applicants who have been
page
allocated
17, page 17, annexure 1
page
is
17.
allocation of calcinide pet coke for 2020.
I'm not for that.
You are not there.
Page 18.
So you are for raw pet coke.
18, 18.
Your license is with, sir. That's you may have both facilities. You can be a calcinizer as well as you may use this RPC for anode making in aluminum industry. But the license says it should conform to a particular standard, BIS standard. So the test should be not that what is your end product. The test should be what is the product imported. Usage is different. Usage is different. You may be using it in an environmentally friendly manner, may also fall within the four corners of the observations of the Honorable Supreme Court. That's not the test because it's a prohibited item. Once it's a prohibited item,
I appreciate, there. What is the reason? There is a requirement of striking a balance.
We will fix the matter in July. We will admit the appeal. Because
two sentences.
You are all big players. SSC is a very big player.
5 minutes.
Already 25 minutes.
Page 18.
The more we hear the matter, it's.
This is not a case now that I am not importing now.
No, even now you can apply. No, even now you can apply for the committee. Please amend my license, and even you can supervise my manufacturing facility. Though this RPC is being imported, it will be used as a feedstock in my calcination plant, not for any other purpose. Therefore, please.
Page 28, that is the letter of the government, my lord. Page 28. That is what I'm saying. Page 28 is the letter of the government on which the Commissioner of Appeal has referred to. This was written by the Central Pollution Board to the Ministry of Environment. Please refer to the Ministry of Environment letter, private comment, etc. In this regard, the report number 71 of EPCA of the Supreme Court order permitting use of imported raw petroleum coke do not mention maximum sulfur content to be imported by petroleum coke calcining unit. Further, there are BI standard for raw petroleum coke and calcined petroleum coke used for anode making in aluminum industry for manufacturing of electrodes, carbon, graphite. But this BIS does not mention that petroleum coke, calcined, which also use RPC, etc. may be this. However, the matter of DGFT may also be taken. So, this entire matter is to be read in the context of what the government is thinking, what Supreme Court has directed, what was meant to be done. So this cannot be all these things of the order of Supreme Court, these licenses on the basis of which I have been issued the license can't be undone on the basis of a simple thing that my import license a condition where I am to meet it. Supreme Court says.
You please say you just gave us this minutes. You come to page 28 of that.
Yes, 28 I am on it. They say it is not.
So they qualified it. They qualified. Please see. In this regard, it's notice report number.
They have allowed me.
Permitting use of imported raw petroleum coke in petroleum coke calcinated units do not mention the maximum sulfur content. But your license doesn't say so.
But my license is, that is what my license incorporates this meeting, minutes of the meeting. Very seldomly, the license says that I will be getting embarrassed. I won't take your lordship's time.
Unfortunately, the tribunal.
Make some kind of an arrangement. My goods are lying at the port, having damages and etc. This order is only for a temporary reason. I'm a factory. I run every day. I'm one of the India's leaders building factory, both the Calcutta and at this both the petitioners. My name is there. I've been considered in Supreme Court. And so this tribunal and Mr. Appeal made an alternative arrangement that you temporary arrangement, you take it and let you decide the issue. Well, this is, according to me, my lord, this is a sentimental question of law, not a substantial question of law. No substantial question of law can arise from a provisional release order.
No, not
Provisional release order.
Not that way. In
Provisional
fact,
release order. Some kind of thing. Otherwise, it is total waste. Already 40 metric ton out of 10,000 is there. Others have been left. They are saying you leave it. I'm within the four corners of Supreme Court. I'm within the order of the Supreme Court.
we will say that
Yes.
we will request the tribunal to decide the matter within 30 days. We'll send it back and we'll say that the tribunal should decide the question when admittedly the sulfur content is in excess of 7%. Does it conform to the Indian standard IS 17049, and whether there has been a violation of the import condition, number one. Secondly, this raw petroleum coke mandately requires a policy condition, whether there is a violation of the policy condition committed by the RC. Third, importantly, when admittedly the license specifies the use of the product for a particular purpose with IS certification number so and so, whether the general conditions which is mentioned in the footnote can be taken along with to what purpose you are using the end product, the raw material, whether the reverse test can be applied.
No, they themselves have withdrawn all my cases, seizure cases, and withdrawn on the basis of that note, which my land friend is doing. My lord will see this, they've withdrawn the seizure. So over where the sulfur was less than 7%, they've withdrawn the seizure and all. And now I've been
So therefore, once you,
metric ton on that basis.
once you comply with the license condition, there won't be.
They say it is license.
Only with regard to the quantity.
My lord, I have this, that they have been, accepted position is this, that they say that 7% it is allowed. Even in the appeal it is mentioned, 7% is allowed. My lord, we kindly see this, the page 8 of this appeal memo. He says 7% is allowed. Page 7.
Page
7 of the appeal. G. DGFT import license issued to the importer provides that description of item to be imported under the license as raw petroleum coke for anode making in aluminum industry. As per parameter was specification message standard, maximum permissible limit in respect sulfur content raw petroleum is 7%. This is everywhere mentioned, and they have withdrawn the proceeding against me where it was found to be.
So therefore, on the second round also, you are bound to succeed before the tribunal. Let the tribunal decide this issue. Saying that no harm will be caused.
Whether my lord will entertain this kind of an appeal where I have followed the law to the hilt, my lord. I have.
This appeal filed by the revenue under section 130 of the Customs Act 1962 within bracket the Act is directed against the order dated 7th March 2023 passed by the Customs Excise and Service Tax Appellate Tribunal East Zonal Bench, Kolkata. The revenue has raised the following substantial questions of law for consideration. Page number 30, question A, B, C. Page 31, question D. Yes, E, F, G not required. We have heard Mr. Kaushik De, etc. Tapan Banja, Mr. Sudhir Mehta. The order impugned, if in this appeal has been passed by the learned tribunal, confirming the order passed by the Commissioner of Customs Port, Kolkata, granting permission for provisional release of the raw petroleum coke within bracket RPC imported by the appellant, imported by the respondent. The revenue is on appeal by contending that in terms of the license granted by the Directorate General of Foreign Trade, Delhi, within bracket DGFT, dated no, date is not there. The respondent was permitted to import petroleum coke hyphen raw petroleum coke for anode making in aluminum industry, conforming to standard IS 17049. The said standard states that the total sulfur, percent by mass, maximum should be 4% for raw petroleum coke and 3.5% for calcinated pet coke. The standard further states that based on the availability of RPC with varying sulfur content, RPC with sulfur content more than 7% is not permitted for making RPC of sulfur content 4%, maximum. Page 38. According to the appellant revenue, the import of raw petroleum coke for anode making in aluminum industry conforming to standard IS 17049 is a prohibited item. And the relevant policy condition is number 6 of chapter 27, which provides the percentage of the total sulfur content. The case of the respondent importer is that they are a calcination plant for which no percentage has been, no sulfur percentage has been fixed under the BIS guidelines. And in this regard, the respondent would refer to the decision of the Honorable Supreme Court in MC Mehta versus Union of India, WP numbers 13029 of 1985, dated the date of the order will not be here.
9th October 2018.
9th October 2018. Wherein the Honorable Supreme Court, after taking note of the report given by the Central Pollution Control Board within bracket CPCB, dated 4th October 2018, has quoted the said report, which reads as follows. Page 13 of Mr. Mehta's compilation. I'll mark it. Thus, according to the respondent, the product imported by them being used in the calcination plant, the restriction on the sulfur content in terms of the BIS standard will not be applicable.
1704.
The learned tribunal, while considering the correctness of the order passed by the commissioner, after setting out the arguments placed before it by both sides, has recorded the submission of the revenue that the goods should not be provisionally released, as admittedly the sulfur content is more than 4%, and the same cannot be used by aluminum manufacturing industry. The learned tribunal has not rendered a specific finding on this submission, but takes note of the fact that the respondent importer is a calciner, CALCINER, and they would use the imported product as a feedstock for making CPC from RPC for their customers, with sulfur content ranging from 0.8% to 3.5%. The question would be as to whether there was a violation of the license condition can be examined by taking note of the end product that will be manufactured by the respondent importer, or should the importer satisfy that the import effected by them is in accordance with the license condition. In our prima facie view, since the product is a prohibited item, the test would be to examine as to whether the imported product satisfies the license condition. Rather, examine whether the import was justified based on the end product that may be produced. The Commissioner of Customs as well as the Learned Tribunal has proceeded based upon the ultimate end product which is being manufactured by the respondent. This, in our view, would be an incorrect manner of examining as to whether the import was proper and whether it satisfies the conditions of license. Furthermore, the tribunal opined that no harm will be caused by provisionally releasing the goods. We are unable to persuade ourselves to accept such a finding, as the question would be as to whether, when admittedly the sulfur content is in excess of 7%, will it conform to this IS 17049 as mentioned in the license? And if it does not, conform to the said standard, is there a violation of the conditions of import? Furthermore, the goods being prohibited item, there is a mandatory requirement to comply with the policy condition. And the tribunal was required to examine as to whether there has been any violation of the stipulations under the policy before considering as to whether the goods have to be provisionally released when admittedly the sulfur content is more than 7%. Therefore, we are of the view that this question, which is a mixed question of fact and law, is required to be decided by the tribunal before either approving or approving the order passed by the Commission of Customs granting provisional release. Therefore, we are of the view that the matter requires to be reconsidered by the tribunal by deciding the above referred questions. Full stop. In the result, the appeal is allowed. The order passed by the Learned Tribunal is set aside, and the matter stands remanded to the Learned Tribunal to decide the aforementioned questions. And the parties are at liberty to make their submissions before the tribunal, and a fresh decision be taken on merits and in accordance with law. Taking note of the submissions of Mr. Mehta that the goods are lying in port and incurring demurrages, we would request the Learned Tribunal to give an early hearing for the in the matter, preferably before July 2023.
There is a direction for retest of the goods that may be carried out immediately without delay. Commissioner of Appeal has directed, tribunal has directed for that. So goods are lying there, so the retest can be done.
That is it's a waste of exercise. It has to go to Mysore.
No. It is done at Kolkata. It is laboratory anywhere in India.
Once you have set aside that order, that liberty you take it. Thank you.
For that they are not aggrieved, my lord. That so far that retesting is concerned. For that they are not aggrieved. So that may be direction because it will save time. Because retesting is not anybody, their own laboratory. It is their own lab.
It is traveled up to the tribunal. The sulfur content has already been determined. Now retesting, date of import, what condition it is being stored, we don't know. Sedimentation will take place, whether it's a PU coated tank or whether it's in barrels.
It is open, lying open, my lord. So they have.
Lying open.
Yes.
Then all the more now the sulfur content will be 1.2%.
So it is lying open, my lord. It is, they have taken sample at that time only, at that time. And
volatile substance. I say so because I dealt with one matter. No matter it's in Supreme Court. It's a very volatile substance. Sulfur dioxide emission within the prison, like 6 kilometer radius, I mean a 4 kilometer radius. Nobody will be able to breathe from.
when it is used as a fuel, when we are using as a feedstock, in that it is not.
Hey, please mute the.
When it is that adjudication should wait till the outcome of this.
You place a letter before the authority saying that you defer the adjudication.
They have done it that when we have, they are fixing
they'll obviously they'll wait.
They will adjudicate the matter and entire proceeding will be over for me.
You come here once if they start.
This they have tried and we have moved high court
No,
once.
Mr. Mehta, we can't revise our earlier order. That is arising out of a writ proceedings. Please.
I'm grateful to your lordship.
Item number 13.
Grateful to your lordship.
Madam, 13 is similar matter, madam.
Same.
Item number 14.
Yes.
I appeal for that.
It's my maiden appearance before your Honorable Chief Justice, my lord.
Yes. Welcome. Most welcome. What is this customs broker?
Yes, customs. My lord, what has happened that sometimes in the year 2012, my lord, betel nuts were imported by two importers, but Sharda traders and Sukanda traders. I was merely the facilitator over there. Subsequently, goods were released by way of provisional release. That has been made by the importers. Now, after a lapse of 3-4 years, all on a sudden, a show cause notice came to me by stating that you are also liable, you are a deemed importer, a new name I found, a deemed importer, and I
was called for an adjudication. Very primarily, I said that I am not the importer, number one. Whatever is the adjudication you do, and I have twofold objections that from what statements you are relying, what documents you are relying, kindly provide me the documents. Thereafter, at the adjudication proceedings, I went there, I give my objection to this, that look, I have not been given with any of the documents. This is one part. Now, I came before, during the pendency of the adjudication proceedings, I came before this honorable court, before the single bench, that this was a matter of section 17, which applies, that they will, importers have placed one self-assessment that will be reassessed. After that, an order will be passed, Lordship, and thereafter, whatever show cause or whatever it is. I found from the record that 17 has not been complied with in totality, nothing. Directly, section 28, a notice has been served. Fundamentally, on two questions I question. Number one, that without affording me the opportunity and all, you cannot pass any order behind my back. You cannot rely upon anybody's statement by inculcating me. That is one part. And the other part is, without compliance of section 17 categorically 1 to 5, until and unless this order comes up, you cannot issue a notice under section 28. That is the pure question of law that we have raised.
But then the learned judge has dismissed it on the ground of delay.
My lord, yes.
2015
my lord, why?
show cause notice.
I'm sorry, my lord.
2020 writ petition was filed.
My lord, I was pursuing before them only. I have all along said that, my lord, I have a specific letter.
The adjudication order has been passed on 27th November 2022.
22, during the pendency.
So therefore, the limitation is not lost because your writ petition was dismissed only on 13th January.
My lord.
And immediately you have filed this appeal.
My lord.
You file an appeal against that order.
My lord, that
That's
we
it,
have
yeah.
also preferred a fresh writ petition. My lord, we may serve the copies. But my lord, my preliminary objection was, I am challenging the show cause notice itself.
That can be done in that writ petition. New writ petition, you say there is a fundamental error right from the commencement of the proceedings. You have said 17
My lord.
So here, how to interfere? Now that the show cause notice has worked itself out, it culminated in order of adjudication. You have challenged it here, you might have challenged it.
My lord, that in the original writ petition also, as and when that original came up, we also annexed it. My lord,
No, that can't be, no. It's entirely
a separate proceedings. My lord,
because how he dealt with your objection. You sought for copies of documents.
My lord.
He would have said, need not be furnished, or he would have said, I have already furnished, or he can take a stand that they are not relied on documents at all. He can take any one of these.
My lord, in the order itself, it will show amply that the persons whom they have relied upon, I have not been given an opportunity of cross-examination. The very fundamental. My lord, that I know, but at the same time, my lord, that show cause what already has been decided.
We will preserve that. In that grounds, you raise that from the inception, the entire proceedings are vitiated.
Well, let that be decided if.
This intra-court appeal by the.
Well, in the meantime, hopefully they will not take actions on that only, because we have already filed. My lord, we are handing over the copies also.
My lord, kindly fix the time period. Within that period, they will prefer the appeal. Nothing will be done in the.
No. He has already filed a writ petition.
My lord.
Already writ petition filed. They have not served. I don't know.
No.
This intra-court appeal by the writ petitioner is directed against the order dated 30th
For department, we have served.
In WPO 171 of 20. The said writ petition was filed by the appellant challenging a show cause notice issued by the second respondent dated 9th October 2015. The learned single bench has noted that the writ petition was filed only on 6th March 2020, after about 4.5 years after the show cause notice was issued. When the writ petition was entertained, no interim order was granted. Therefore, the adjudicating authority has proceeded with the adjudication, and the show cause notice has culminated in an order in virginal dated 27th November 2022. Thus, in our view, challenge to the show cause notice at this juncture cannot be entertained, and the learned writ court rightly refused to entertain the relief sought for, nor permitted the appellant to bring on record the order of adjudication dated 27th, 2022 by way of a supplementary affidavit. However, the learned writ court granted liberty to the appellant to file a statutory appeal as against the said order of the adjudicating authority. Mr. Ganguly, learned advocate appearing for the appellant, submits that as against the adjudication order dated 27th November 2022, the appellant has filed a writ petition in WPO number
WPO number 913 of 2023.
913 of 2023, and the same is pending before the learned single bench. If such be the case, there is no necessity for entertaining this appeal, and it would suffice to clarify that the appellant is entitled to canvass all grounds in the said pending writ petition, since the appellant would contend that the very initiation of the proceedings by issuance of show cause notice is in violation of the provisions of the Customs Act. That apart, the appellant appears to have also canvassed the grounds, also canvassed the correctness of the adjudication order dated 27th November 2022 on various other grounds, including the ground of violation of the principles of natural justice. Thus, by giving liberty to the appellant to canvass all grounds, as mentioned above, we dispose of this appeal.
My lord, one prayer, my lord. Your lordship has take the point of mentality before the honorable single judge.
Needless, Mr. K.K. Medil and a senior standing counsel for the respondent submitted that the fresh writ petition filed by the appellant is not maintainable, as the order of adjudication is an appellate order, appealable order. This objection, full stop, not this. It is open to the respondent revenue to raise such a plea before the learned writ.
In the meantime, my lord, some protection, otherwise, my lord, at least for some weeks, my lord, so that it may be hard.
In that writ petition, you move a stay application.
My lord, that there, my lord, lordship knows, my lord,
Very
only 2 days are left.
2022 adjudication.
My lord, the adjudication.
You manage for some time. Next.
Item number 15.
Yes, sir. What is this? No delay. Delay condoned is.
But here below the moot questions regarding section 43 capital B, my lord. The sales tax liability which was, my lord, accrued, my lord, on the year it has to be SSC can claim deduction on that year only, but previous year's deduction claim cannot be allowed in particular year. That was the subject matter.
No. It should. In which year it got crystallized?
Yes, in which year does it got crystallized? So actually in this case, my lord, the claim of earlier 5, 6, and 6, it was crystallized. The claim was of 5, 6, and 10, 11. It was crystallized in 13, 14. So, my lord, whether that has been, it will be.
See the tribunal.
Yes, I have seen.
Liability of sales tax payment of 12 lakhs are not crystallized using AY 1314.
Yes.
Post sales tax assessment completion.
Yes.
Assessee made the payment during the year, which is not in dispute. Therefore, in our considered view, 43B squarely applicable on the sum assessed, and the assessee has rightly claimed its deduction for the income in 1314. Given fact and erred in sustaining the disallowance. Rightly so.
This is the only question, Lord.
This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961, within bracket the act is directed against the order dated March 30, 2022, passed by the Income Tax Appellate Tribunal A Bench, Kolkata, in ITA number 64/KOL/2022 for the assessment year 2013-14. The revenue has raised the following substantial questions of law for consideration. Page 2 and 3, question number A, B, and C alone. D not required. We have heard Mr. Prithu Doria and a senior standing counsel for the appellant. We find that the learned tribunal, after noting section 43 capital B of the Act, and that the said provision commences with a non-obstante clause, has considered the factual position in the case on hand and has recorded the following finding. Page 24, paragraph. The revenue is unable to dislodge the above factual conclusion arrived at by the learned tribunal. Thus, we find there is no question of law, much less substantial question of law arising for consideration in this appeal. Appeal dismissed. Next.
Item number 16.
My please, your lordship. Now, this is a matter, my lord, wherein on the last occasion, my lord had directed me to, my lord, notify the respondent once more. I could not do that, my lord. May I come back, my lord, after the package? Delay has been condoned in this matter.
68. Share capital.
My lord. And there is no explanation, my lord. And even, my lord, one of the ground that, my lord, this SSC was not traceable.
Whether senior counsel will appear in this matter. S.K. Tulsian appeared for the tribunal. Asta Wincom. You have served notice? No.
No, my lord. Subsequently, your lordship had directed me to serve it again. That I have missed, my lord.
Okay.
I have missed that. My lord, serve it through mail and then, my lord.
Mail. We have heard Mr. Tilak Mithrol and it's standing also. Let fresh notice be served on the respondent SSC through email.
Right.
List after service of notice.
Extremely grateful.
Item number 17.
Fresh notice through email to the registered email ID.
This is my appeal.
What is
Here
this?
the issue is involved is
Exemption.
exemptions matter. My
And
lord,
according to you, what happened?
there are
No charitable activity done.
yes, my lord, under section 11, the SSC can set apart amount for specific purpose. And what the amount which is set apart will not be taxed. But there are certain conditions that those amount needs to be utilized within next 5 years. If the SSC fails to utilize, then that will be
Offered for taxation.
My lord, here in the year assessment year 10-11, 12 crore 10 lakh rupees was set apart by the SSC. But the SSC failed to utilize amount. So,
But it's a 263 order.
yes, my lord.
But the tribunal says it has been utilized in the 6th year.
Tribunal holds that it should be taxed in the 7th year. But it was not utilized in the 6th year, my lord. How? I'm showing that. My lord, kindly note that assessment year, my lord, when the amount was set apart, 10-11. Admittedly, SSC utilized only 1 crore 35 lakhs. And 10 crore 74 lakh lakhs odd was to be taxed. But SSC itself offered 3 crores, 3 crore odd lakhs for tax. And 6 crore 85 lakhs was to be taxed.
No, let us see.
My lord, if my lord, it has to be in the 7th year, SSC should not have offered.
No, let us see section 11(2).
Yes, my lord. My lord, kindly see, come at page, my lord, 26, my lord. Here it is given.
We'll have the book, it's better. No, this is section. Income from property held for charitable reason.
But the printed page 1.154 is subsection 2 regarding accumulation and
where 85%.
and with 3 is on at 1.156.
This is the part regarding accumulation, then subsection 3, my lord. Page 1.156. 3, clause C.
Yes, is not utilized for the purpose for which it is so accumulated. Set apart during the period referred to in clause A of that subsection, or in the year immediately following the expiry thereof.
Yes, ma'am. Thereafter, my lord, when it is to be taxed, this is also mentioned. It shall be deemed to be the income of such person, my lord, after D. After D, shall be deemed to be the income of such person of the previous year in which it is so applied or ceases to be so accumulated or set apart or ceases to remain so invested or deposited or credited or paid, or as the case may be, of the previous year immediately following the expiry of the period aforesaid. The period is 5 years. Means after expiry of that 5 years, the amount should be taxed.
No, if this interpretation is accepted, clause C becomes redundant.
No, my lord, as per clause C, this is part of clause C, my lord.
True,
This is
shall
part
be
of clause
deemed to be the income of such person of the previous year. Which will be deemed to be income is not utilized
Yes.
for the purpose so accumulated or set apart so and so, or in the year immediately following the expiry thereof. What is the year which is immediately following the expiry thereof? It is the 6th year.
1617, my lord.
So that's why the tribunal says from the 5th year, next following from the end of the year in which the amount was accumulated or set apart, then whatever is unspent has to be utilized in the 6th year, failing which it will be brought to tax in the 7th year.
There is the distinction, my lord. Tribunal has done what is the statute says. The amount needs to be utilized in the 5 years.
This aspect was examined by the AO.
No, my lord, that was not examined. That's why 263 was invoked.
No, did the PCIT call for the assessment file?
Yes, ma'am.
Because it's 263 order.
Yes, my lord, 263 order at page 25, my lord. My lord, kindly come to page 26.
He has discussed everything, sir. If I am right, page 19.
Page 18 is where he has added back
Yes.
6 crore.
6 crore and odd.
Serial number 4. 6 crore 50 and 35 is out of the accumulated amount is added. Would not that 3 crore which the commissioner wants to add that was spent during this year. So the officer has looked at it, he's found this is not spent. and he's added this amount, the rest of it. So that this is undisputed. This is to be added. So that 3 crore 33 commissioner says should be added back because it is the 6th year and you're not spent it. Now, the section my lords have seen, it says, I get 1 more year.
Yes.
And what the rest of the section which my learned friend placed, it says the period, kindly see the subsection 3. Clause C, my lords have seen, is not utilized for the purpose for which it is so accumulated or set apart during the period referred to in clause A of that subsection, or in the year immediately following the expiry thereof. So, 5 plus 1, 6. Now, the rest of the section shall be deemed to be the income of such person of the previous year in which it's so applied or ceases to be so accumulated or set apart or ceases to remain so invested, deposited or credited or paid as the case may be of the previous year immediately following the expiry of the period aforesaid. So the period aforesaid is 6 years. I've spent the money. Officer has seen it. Whatever I'm not
It's
spending.
not a 263.
My lord, my interpretation is different.
No, no, your interpretation, your commissioner's interpretation is wrong.
My
This
lord,
man has examined everything. Where is the question of
my lord,
failure to disclose or the assessment being erroneous? Twin condition not satisfied.
my
Dismissed.
lord, the tribunals ordered, in the tribunal order, that thing is not mentioned.
We will raise that question. We will raise that question.
SSC has utilized this in
First
the 6th
question
year.
will be whether the learned income tax tribunal was right in interfering with the exercise of or interfering with the assumption of jurisdiction under section 263. You will go on. Fellows are doing something, you leave all other bogus donations, circular transaction, you will.
My lord, in my estimation, what the section says, that amount needs to be utilized in 5 years, my lord.
You read the section.
My lord, yes.
Then if your interpretation is accepted, the words in the year immediately following the expiry thereof becomes redundant. You have to strike it off. And it has been utilized in the 6th year. That's what the AO notes. Please come. This appeal by the revenue filed under section 260 capital A of the Income Tax Act 1961. Within bracket, the act is directed against the order dated 11th July 2022.
But
passed by the Income Tax Appellate Tribunal.
One thing, my lord. If kindly, my lord. Here, what is the finding of the tribunal, my lord? My lord, the tribunal doesn't say that it was utilized. Because if the amount was utilized, my lord, the tribunal should not have held that it needs to be taxed in the 7th year. This is the 7th.
Spent is my
lord, it is a finding of the tribunal that it is to be taxed in the 7th year. That means amount was not utilized.
But page 30, my lord, just please
my lord,
paragraph
kindly
5.
come to page 31, my lord. I'm reading out, my lord. Having heard the rival contentions and perusing the material on record, and after going through the provisions of section 11.2, 11.3c of the Act, we are of the view that whatever is accumulated under section 11.2 of the Act, upon being falling short of 85% of the total revenue of the trust, can be accumulated for a period of 5 years, subject to fulfillment of certain conditions as emphasized in that section, and shall be spent on the objects of the trust during the maximum period of 5 years, 5 following years, as set out in the Form 10, filed by the trust along with the return of income. We have
page 30, paragraph 5, 7 lines from the top.
No, no,
was spent in the 6th year.
That is, my lord, here what is, my lord?
Thank you, Mr. Sharma. Thank you, thank you, thank you.
This portion, my lord.
Income Tax Tribunal, B Bench, Kolkata, and ITA number 200/KOL/2021 for the assessment year 2016-17. The revenue has raised the following substantial questions of law for consideration. Page number 6 and 7, 1, 2, 3 alone is sufficient. We have heard Mr. Amit Sharma, learned senior standing counsel for the appellant, and Mr. J.P. Ketan, learned senior advocate, appearing for the respondent assessee. The first question to be considered is whether the Principal Commissioner of Income Tax, not a Principal Commissioner, the Commissioner of Income Tax within bracket exemptions, Kolkata within bracket CITE, could have exercised power under section 263 of the Act. As could be seen from the assessment order which is assessment order dated 9th April 2018, passed under section 143 within bracket 3 of the Act. The assessing officer has made an elaborate exercise. And in the computation of income, the following has been recorded. Page 18, sir. Has been recorded. Full stop. Before the tribunal, the assessee specifically raised a plea that the assessment order is neither erroneous nor prejudicial to the interest of revenue, as it has been factually established that the unutilized amount was spent in the 6th year in terms of clause C of subsection 3 of section 11 of the Act. And after having 11 of the Act. Though such a plea was raised, the learned tribunal took note of the undisputed facts and held that the unutilized amount cannot be brought to tax in the 6th year, but can be brought to tax in the 7th year if it still remains unutilized. In our view, we need not travel thus far to take a decision in this matter, as we are fully convinced that the Commission of Income Tax Exemptions, CITE, has not recorded as to how the scrutiny assessment was either erroneous, or prejudicial to the interest of revenue. Unless and until the twin tests have been satisfied, the power under section 263 could not have been exercised. Thus, we find no grounds to interfere with the order passed by the learned tribunal. Accordingly, the appeal stands dismissed. I'm ready.
Before rise, may I seek your lordship's indulgence? This matter has been released today by Justice Vishwajit Basu. Justice Vishwajit Basu has released this matter, these 3 matters. Since the division is in session of the matter, if this matter is assigned as early as possible.
Make a request immediately. Till today,
only 2 days is left. That's why.
Till today, no file is pending in my table. Every day evening by 8 p.m., I close all the matters and then leave. You make a request to the OSD, it will be placed.
May I mention, my lords, item 24 in my lord's list today, my lords. It may be taken up tomorrow or day after, my lords. Any day.
Continue, no? What will happen? It will be there. Only hearing will be after vacation. Your matter, if it is a fresh matter, it will come up. It will be in the list.
Obliged.
Supreme. Yes. Extension has been granted.
Yes. Acha, another touch. Acha.
Arjun, order sheet is there, last order. So it's 13th April. 13th April. Yes, what shall we do, AJ? How much time you would require?
My lord, first is, my lord, I'll seek an accommodation as to the date. I'm even willing to do it today. But my lord, I won't be there, my lord, the first week. So, my lord, any date, my lord, second week of my lord, court reopening.
The court officer says 3 full days is required.
No, not for me. I don't think, my lord.
All of you put together 3.
My lord, yes, my lord, your lordships, my lord, order, last order records the submissions, penultimate paragraph, as to, my lord, last 4 lines.
Require minimum 3 days.
Yes, my lord, my lord.
Then Mr. Bachawat will have a short reply.
Very happy to
No.
have the last word.
We'll fix it on 15th June. 15th June for the full day.
I'm grateful, man.
Because this group 9 PIL is taking so much of time. And there's every day around 10 people are mentioning urgency, etc. So 2 days I was not there. That has added to the pressure. Reference may be made to the order dated 13/4/2023, which reads as follows. Please quote the order. In an application moved by one of the parties before the Hon'ble Supreme Court, in miscellaneous application number 529 of 2023, in SLPC number 8668 of 2021, the Hon'ble Supreme Court, by order dated 17/4/2023, has extended the time limit till 31st July 2023. The said order passed by the Hon'ble Supreme Court is placed on record. As submitted earlier, the learned advocates appearing for the parties submit that they would be requiring 3 full days to conclude their submission. On account of pressure of work, we will not be able to assign 3 full days continuously. As agreed to by the learned advocates, let the matter appear on 15th June. So this will be reply submission.
My lord, it is really, my lord, what in Delhi, my lord, is termed as, my lord, sir rejoinder.
Sir rejoinder.
My lord, we don't have
a reply is already
yes,
over.
my lord, everybody is, my lord, argued. My lord, they've had a response. Go at, my lord, our reply.
But the problem will come in the sir rejoinder if suppose some new issue is brought up. Then they have to be heard.
Not just that, there was a cross objection where my learned friend was the.
My lord, I have argued, my lord, the cross objection. Will cover, my lord, my rejoinder in the cross objection in this as well. So
Technically, I may have a right there, but I may not trouble your lordship.
Let us keep things open. No. Yes, 15th June.
Your lordship's permission, my lords.
10:30. 10:30.
With your lordship's permission.
Anything else? That's all. Once again. Yes, Madam Musa.
My lords, your lordship is posted for the 16th of June, my lords, but as your lordship knows, the month of June is vacation in the Supreme Court, my lords. Would your lordships consider 15 minutes on?
You can plan your vacation to Calcutta.
My lords, it's not for me, my lords, it's the senior advocate.
My lord, I'll have a word with Mr. Sundaram.
No, by then the weather will improve. June 15th, I think the rains will start.
My lords, it's not about my convenience at all, my lords. Would your lordships consider 15 minutes in July, or would your lordships be finishing it in June itself?
No. See, let them start. 31st July is the last day. So what we'll do is let them make the submissions, but you won't be there. Somebody else, who else will be able to record?
My lords, recording of the submissions, I will manage it, my lords. That's not the problem. It's only for the.
It's live streaming is there. You can always play back.
Quite
so
right.
that won't be the issue. You make some arrangement so that somebody, if they want, let them take notes.
Please.
And thereafter, we'll, subject to convenience of Mr. Sundaram, we'll do something.
I'm very obliged.
But APL can't have the last word. It's not a party. It's not an appellant. It's nothing.
Keep
Anyway,
things open. Sir. Keep things. Plans are always open. Okay.
I'm very obliged, my lords.
may I, my lord, in a precarious situation, my lord, I am, my lord, memorandum of appeal already, my lord, filed online with certified copy, my lord. This is the, my lord, stay. My lord, for last 4 days, my lord, I could not, my lord, upload the, my lord, stay because of, my lord, my lord, so my lord, leave can be granted with the physical, my lord.
This is a problem throughout the country.
I know, my lord, I know, my lord.
I think by today evening they will resolve it.
But if your
We have
lordship grant,
discussed with NIC Pune also.
if your lordship grant me, my lord, tomorrow is the, my lord, practically tomorrow is the last day, my lord.
Yes, leave grant.
My lord, let me allow to give me a leave, my lord. Regarding the electricity matters, the order has been passed by Honorable Justice Subodhaj Mukherjee. It is a very urgent matter.
May please, your lordship, may I permit to mention? There is a more urgency matter. Matter is relating to BSF.
Pardon?
Without that.
Matter is relating to BSF, Border Security Force. Matter is in the list, item number 458. But apart from that, on the earlier occasion, the Honorable Chief Justice passed an order, let it be heard on 16 January.
You please give the, get the file, no?
My lord, may I have your lordship's leave to mention a matter, my lord? It is a, my lord, recalling application of your lordships, my lord. They dismissed on for default on 13th, my lord.
Please, please. Yes, please.
May I have your lordship's kind leave to mention one matter? This has already been mentioned before your lordship. This is in regard to the death of Kharagpur IIT student, lordship.
Kharagpur,
Yes, yes, lordship. The matter has been fixed on Friday before the single bench, before the honorable single bench. Lordship kindly keeps the appeal tomorrow.
It is already filed.
Yes, yes.
It's running in the list.
No, not, it should have come to in today's list, but
I was
it's
not
not
there
there.
for 2 days. No, I was not there for 2 days.
Yeah.
So tomorrow we can list. Tomorrow? Tomorrow.
Grateful, lordship, great. Lordship,
But may I have your lordship's kind leave to mention item number 98, my lord. This, my lord, pertains to horses in the Maidan area. Your
Yes.
lordship is well aware, my lord, that 16 horses are in, my lord, injured condition, my lord. They cannot be, my lord, used for.
But we have
draw the
issued some
carriages.
directions.
Yes, my lord, my lord, and we have held meeting, my lord, and it has, my lord, come out, my lord, none of them, save and except the petitioner being the PETA, is agreeable to take the custody of the horses to look after them, my lord.
You are appearing for?
I am appearing for, my lord, PETA.
PETA.
My lord. So, my lord, kindly, my lord, if your lordship, my lord, this matter can be, my lord, hard, my lord.
Immediately after.
My lord, the condition of the horses are, my lord, really, my lord, bad. My lord, report has come, my lord, that they, my lord, require immediate, my lord, treatment, and they, my lord, cannot be, my lord, used.
No, regarding that horses, 16 horses, we have said that they should not be put to commercial use.
Certainly.
And they have to attend the camp, etc.
Yes,
And there is a suggestion to transport the horses to a place. And they have agreed to undertake that exercise. And last, is additional.
On 8th of your lordship passed on in direction on 8th of May, my lord. And pursuant to that, my lord, we, my lord, held the meeting. And
what is the outcome of the meeting?
My lord, so far as the outcome of the meeting is concerned, my lord, they have the people from the Hathani carriage of the police was present in the meeting. Yeah, and the animal husband.
No, what about the horse owners?
Only one of the four persons appeared, but they said they have no objection if we take custody of the horses.
Very good. Actually, 8 of them were already there. They had filed applications and we heard them. The advocates for those 8 horses.
Yes.
Owners.
Yes.
You do something to it. We don't know within the next 2 days.
Can you not, if it is kept under to be mentioned, I think, my lord, much time will not be, my lord, consumed to take us, my lord, certain direction, my lord.
So let Mr. Chatterjee inform Mr. Banerjee, and you get instruction and report to us tomorrow.
Lord, may my learned friend communicate to me what is the difficulty? Lord, I'll ensure what.
Then tomorrow you can mention both of you. First, both of you discuss what has happened.
Then tomorrow I'll come.
And you can come back tomorrow.
Great.
Yes.
May I be permitted to mention urgent application for stay? Honorable single bench judge person ordered the respondent, and number 1 is making boundary wall on the disputed and unpartitioned plot. So can the matter fixed for tomorrow?
Fresh matter. Yes, Mr. Muraka.
May I mention a group 4 appeal for listing tomorrow, my lord? There's some urgency.
My stock in trade has been seized contrary to section 132 of the Income Tax Act, my lord, and is not being released. My lord.
And Mr. Dutt, you are appearing?
I am appearing. My lord, the goods were seized in November 2022.
You
So,
move the
my lord,
vacation court.
Lordship, kindly take it up. It's very short, my lord.
My lord,
My lord,
I
my
have
lord,
to take, I had to take instructions in this matter. I
You
can't-
take instruction, you move the first vacation court.
Lord, I'll take my chances before my lord's bench.
It will be item 120, don't reach. If you
My
take a
lord,
chance.
Lordship, kindly
on
take 5
reopening.
minutes, my lord. Lordship will hear my leader. Tomorrow, Lordship has whole day. I'll take my chances. Kindly listen tomorrow. From November,
What
they are not releasing, my lord.
What about matters already listed for tomorrow?
Lord, I'll take my chances. Lordship lists it on Friday.
If we list it, you can't move the vacation court. You move the vacation court.
Lordship,
Kindly,
let
my
it
lord,
be
I won't
listed.
be there in the vacation. Kindly keep it after the vacation. Just on reopening date.
Lordship in the
We
vacation.
will not say anything. So please call the list. Yes.
Lordship,
Sorry,
kindly,
Mr. Muraka. Sorry.
Appellate side, daily list, item number 1.
What is the mistake?
My lord, there have a mistake of the determination. I have filed appeal matter in this court, but unfortunately, as per advice of my senior, this matter will be treated as a writ and which will be filed in the courtroom number 17 before the Justice Obijit Gangopathai. That's why I want to withdraw this matter.
You want to withdraw?
Yes.
I am for the respondent number 2.
The learned advocate appearing for the petitioner seeks permission to withdraw this writ petition. Such submission is placed on record. Writ petition dismissed as withdrawn. Next.
Item number 2.
Item number 2, I beg to represent the appellant. My lord, appellant is no more interested to proceed with the present mandam of appeal, my lord. This is the instruction addressed to the advocate on record.
Yes.
May I be
Place
permitted
the
to hand over?
instruction.
the-
My lord, I appear for the writ petitioner, respondent number 8.
You have heard so and so. The learned advocate appearing for the petitioner has appellant has placed a letter addressed to him by the appellant stating that he seeks to withdraw the appeal. The said letter dated 6th May 2023 is placed on record and the appeal stands dismissed as withdrawn.
We are grateful, my lord. I'm good, my lord.
Item number 3 to 28. My lord, I appear on behalf of the regulatory commissions, one of the respondents.
I'm appearing for the licensee company in these matters, my lord.
That is DVC.
My lord.
Sorry.
And this is against the same order?
I have an application which is, my lord, an application for modification of an earlier order passed by your lordships on 19th of April. That is appearing as item number 18. Other applications, my lord, I'm not very certain of, my lord, what.
But
I have one application, my lord, appearing along with
who's
item number.
appearing for item number 3?
I'm appearing for the respondent licensee company in all the appeals, my lord. All in from item number 3 onwards, my lord. I'm appearing for the licensee companies.
Why it is listed? So therefore you listed everything, is it? All right. In which item application is filed? This is item number?
3 to 20.
Item 8. And who? 18. Who's appearing in item 18?
My application.
Yes.
I am.
What is the prayer?
My lord, the prayer is for modification of an earlier order passed by your lordships on 19th of April. I shall come to that, my lord. The order is really at page 67.
Retain a sum of rupees 1.5 crores on account of first and second installment out of allow the remaining to adjust the remaining amount.
May I briefly give your lordships the background, my lord? My lord, various, my lord, petitioners, including my client, had, my lord, challenged the disconnection notices issued by DVC on them.
Yes.
My lord, it was on the basis of, my lord, a tariff order fixed on 5th of May 2022. Now, the writ petition was filed on 3rd of March.
The notice was given, my lord, on 24th of February 2023, giving the client, my lord, the writ petitioner 15 days time. That was expiring sometimes, my lord, possibly on 11th of March. 11th or 12th of March. Now, my lord, the writ petition was filed on 3rd of March. It appeared in the list on 9th of March. Unfortunately, my lord, it may come back to your lordship's mind that at that point of time, for few days, my lord, the code, we did not work. I would say in this manner, my lord. We did not work. Sufferance was of the client. Now, my lord, what they did was, my lord, the disconnection was effected on 12th of March. Disconnection was effected on 12th of March. The writ petition was taken up for hearing on 13th of March. And my lord, all the writ petitions were heard together, and my lord, judgment was reserved saying that it would be CAV. Now, at the threat of, my lord, labor discontent and, my lord, paying penalty to the, my lord, ultimate suppliers of my goods, my lord, my client had paid the entire amount of 12 crores and odd on 13th of March, on the same day. 13th of March, it was heard. Since it was made CAV, and really we did not know when the judgment. 16th of March, the judgment was delivered. Unfortunately, before that, my lord, the payment paid 12 crores and odd. 12 crores and odd. Now, if your lordships are pleased, one paragraph of that order, my lord, of 16th of March, if your lordships are pleased to come to, my lord, page, it starts at page 46. Yes. Kindly come to page 56.
16th of March.
Yes. 46, paragraph 46, my lord. Hence, the discrimination meted out by DVC in issuing the disconnection notices against the present writ petitioners selectively is palpably without jurisdiction and deers the law, causing gross miscarriage of justice, which is liable to be set aside under Article 226 of the Constitution of India, being violative of the doctrine of equality embedded in Article 14. The writ petitions were allowed. Unfortunately, my lord, on 13th of March, when the hearing took place, by that time, my disconnection had come into effect. They had disconnected. There was an interim order on 13th of March saying that they will not disconnect anybody's connection. But by then it was disconnected. All right. Now, what is, you want this adjustment to be made? Yes, my lord. What is this first and second installment? My lord, I will tell you, my lord. I have to go on paying, my lord, the current dues. Current dues, yes. I was praying that, my lord, the money is lying with them. Let them adjust against that. Because if your lordships are pleased to come to your lordship's order at page 67. No, what we did was we said no disconnection. No disconnection. Wherever disconnection is there, reconnection to be made. Yes. On payment of the. Kindly come to the order once, my lord, page 66.
No amount of money.
Kindly come to page 69. Paragraph 8. We make it clear that insofar as the cases where consumers have paid, which according to the writ petitioner was on account of pressure exerted on them, be that as it may, those payments shall be retained by Damodar Valley Corporation, and consumers cannot seek any refund of those payments pending disposal of this appeal. So I do not want refund. Want adjustment. It is indirectly a refund.
It would be hard, my lord.
The difficulty, my lord. We'll somehow hear this matter out on sometime in July. Yes, my lord, your lordships have been pleased to fix. At least, my lord, may I make this submission? My lord, it's not in the prayer. Now, my lord, if a consumer fails to pay or delays payment, my lord, they impose heavy delay payment surcharge. In the event you succeed, yes, and probably we can you can mention at that time, ask them to give reasonable interest, and that can be adjusted. Kindly provide that, my lord. Otherwise, no, that we will do it at the when we hear the appeal and dispose it of. We'll keep it in mind. We will say that necessary orders. We will record your submission, not take a decision. That order will keep it intact. Very well. This application has been filed
Consumers are drifting.
by,
My lord, for half a minute, my lord, just I'm submitting, my lord, on 12th of May, my lord was pleased to hear one of the applications of one of the consumers, where my lord was pleased to pass an order, my lord, to the effect that I had submitted, my lord, specifically on instructions that lot of consumers, my lords, under the garb of the order of 19th of April, 2023, my lord, they are drifting to other licensees and they're not paying at all without paying. My lord, crores of rupees are just getting drained away because they are saying they are just drifting out. My lord has observed also in that order on 12th of May, 2023, they have not.
if they are not paying, you disconnect.
My lord, we are disconnected, but they are not paying further. They have changed to other licensees.
All right. Now you forfeit their security deposit.
My lord, that is forfeit because the crores of money they are consuming per month.
But how to recover?
My lord, that is the difficulty. My lord, now people are saying we want a refund, but they are just drifting out to other licensees. They're just taking this order. No coercive step is there, pursuant to my lord's order, my lord. No coercive step is being taken by the licensees, in spite of the fact they are just drifting out to other licensees.
No, you file an application.
My lord, we are filing.
Application.
My lord, we are filing an application for modification of my lord's order. My lord.
If he is an errant consumer and he is drifting away, we will say that it will not prevent you from initiating proceedings, whatever under your regulations, your license.
Well, it's very difficult, but my lord, we are filing applications.
My lord, this order provides that, my lord, the consumers will give. Those who are protected, they would give undertaking to the court.
But no,
must be they have given.
Some of the consumers are not given undertaking also. They have just drifted away to the other licensees.
These paper undertakings, how will you enforce?
Exactly, my lord. These paper undertakings cannot be enforced, my lord.
Then you attach their property.
My lord, in fact, we have no security mechanism. My lord, that is.
No. See, in the case of default.
Yes, my lord.
There are two methods. One is disconnection.
Yes, my lord.
He doesn't enjoy the benefit of the supply.
Yes, my lord.
Second is how do you recover the arrears?
My lord, Public Demand Recovery Act, my lord, which is there like that. But that is, my lord, that is not enforceable because they don't have property.
Then you amend your regulations.
My lord, since there's no coercive steps is pursuant to my lord's order, my lord. So
we file a petition, we'll see.
My lord, we are filing, my lord, deeply obliged, my lord.
This can number 1 of 2023 in MAT 519 of 2023. This application has been filed by the respondent in the appeal, seeking for modification of the order and direction dated 19th April 2023 by directing the appellant Damodar Valley Corporation to retain a sum of rupees 1,50, 72, 752 on account of the first and second installment out of rupees 12,05, 82, 012 and allow the respondent allow the applicant / respondent to adjust remaining amount in subsequent bills to be raised by DVC. In the order dated 18th April,
19th April
2023, the following observation / direction was issued. Page 69, para 8. In terms of the above direction, the consumers who might have remitted the bill amount as raised by DVC were not entitled to seek for any refund of those payments pending disposal of these appeals, and such payment shall abide by the ultimate result of these appeals, In such circumstances, the question of modification of the said order by directing DVC to accept, adjust the first and second installment from the amount already paid by them on 12th of March 2023 is not feasible of consideration. The learned senior advocate appearing on behalf of the applicant consumer submits that on account of the disconnection which was effected on 12th of March 2023, the applicant was compelled to pay the entire amount. And on 13th of March 2023, when the writ petitions were heard, an interim protection was granted by the learned writ court. But such interim protection did not inure in favor of the applicant, as by then more than rupees 12 crores had been paid. Therefore, it is submitted that in the event the applicant is successful in these appeals, then the interest of the applicant should be protected. As already noted, the order and direction contained in paragraph 8 of the order dated 19th April cannot be modified at this juncture. It would suffice to observe that in the event of appeal, necessary prayer for protecting their interest, their interest with regard to the amount already remitted by them can be sought for, as there is a prayer for payment of reasonable rate of interest on the amount so paid. With this liberty, this application stands disposed of. Lordship. Then what is your application, Mr.
My applications is for improvement, my lord, pursuant to the, my lord, order passed by the learned single judge. My lord, what happened, my lord, is the second set of appeals.
Which is your
27, my lord, MAT 530. There is, my lord, CAN 2 is there.
number?
27. There was a judgment delivered by the Hon'ble learned single judge on 16th March 2022, 23, my lord, protecting the interest of the consumers, my lord, on the basis of the order passed by the learned appellate tribunal.
Yes.
Now, DBC preferred, my lord, appeal against the said judgment, my lord. There are, my lord, second set of appeals, my lord, your lordship had recorded in your lordship's earlier order. Now, some writ petitions were pending, which was not covered by the judgment of the learned single judge. My lord, where that same demand was made for the area charges pursuant to the tariff order. Now, when our writ petitions came, my lord, the DBC submitted that since an appeal has been pending, your lordship kindly deferred the hearing. Now, after your lordship passed the order, my lord, on 19th of April, my lord, then the matter again came up before the learned single judge. And if you lordship kindly consider these orders passed by the learned single judge. My lord, I want, my lord, learned single judge. And I am for, my lord, Purulia Metal Casting Private Limited. And kindly take the order, my lord. Next, the second paragraph, my lord, we had to file an undertaking, my lord, just like, my lord, my learned senior friend, we have already paid 2 installments. Now the rest they want the recovery. My lord, that is why our writ petition was pending, because that could not be recovered, my lord, since the matter is pending before your lordships, and we are also covered by the judgment delivered by the learned single judge.
No, when your writ petition was filed,
yes,
you had a benefit of interim order.
No.
Before that, you had remitted the money.
No, my lord, in my case, my lord, there are certain dues, my lord, they disconnected my electricity, my lord, we paid the dues, my lord, when you asked for restorations, my lord, they said you have to pay the area charges pursuant to the tariff order.
So that stay has been granted?
No, that stay, my lord, the writ petition was filed, my lord, you will also kindly take the earlier order of the learned single judge, my lord, annexed at page.
No, you want to intervene in a appeal filed against another third party.
Against, my lord, appeal filed by the Damodar Valley Corporation, my lord, against the order passed.
This is not a public interest litigation.
No.
For you to either support or.
No, my lord, what happened, my lord?
No, he will object to your prayer. I don't want this Purulia to come inside.
My lord, kindly take, my lord, the next page, like page 2 of the learned single judge's order. My lord,
yes.
That despite the division bench in appeals arising from connected issue having directed restoration of service connection subject to payment of usual charges, the petitioner is being deprived of such benefit. I am not that, my lord. The petitioner whose electricity connection has been restored after disconnections, my lord, this is my portion, contains that since the dispute as to my lord, payability of the arrears for the relevant period on the basis of the subsequent assessed tariff order is still subsisting, the arrear charges of such period ought not to be claimed by the Damodar Valley Corporation for the purpose of sustaining the electricity connections which has been restored. It is further clarified that petitioner is willing to go on paying the current electricity. It transfers from the order, now the third paragraph, it transfers from the order of the division bench in the several appeals preferred against the connected issue. The division bench gave benefit in 2 separate set of appeals. In one set, the DBC is to retain payments made by the writ petitioner subject to filing of undertaking by the said consumer before the DVC, that in the event the said appellants are unsuccessful in the pending appeal, they would be liable to pay the demand made by the DVC on account of arrears. And in the second group of appeals, the service connections of the petitioners would be restored subject to it. However, since the petitioner, this is WPA 5733, is not a party to the appeal, it is submitted that the petitioner ought to be benefited with the same relief as granted by the appellate court. In fact, we asked for the same relief as granted by the learned single judge by the judgment dated 16th March. Now, since the right claimed at the present are on the strength of two facts, one, the order of this court, which is not challenged before the appellate court, my lord, it is not correct because they have already challenged it in the appellate court.
You have not challenged.
I have not, because I was protected by that order. I filed the writ petitions claiming the same reliefs. And secondly, the order of the appellate court itself, neither of which can be directly implemented at the present scenario, since the petitioner is not a party to the said appeals, as well as because the order of this court being sub judice before the appeal court, it would only be prudent to give liberty to the present petitioners to renew the prayer for restraining the DVC from claiming further amounts before the appellate court, which is in cessation of the entire dispute. Such liberty is thus granted. Now, kindly skip, my lord, the page. Kindly take, my lord, page 4, last paragraph. Such, however, is without prejudice to the liberty of, that is a supplementary affidavit, to approach the appellate court for impediment / appropriate orders of clarification
No,
with regard to the
Mr.
existing
Bandavaria, you file an appeal against this order. You file an appeal against this order, then we can't do that in somebody's appeal.
In fact,
This is Ispat Damodar Private Limited. He is a third party. Like you, he is a separate consumer. DVC has filed this appeal. If whatever you want, we are not, of course, we shouldn't be advising you. If the correctness of this order in some form is brought before the division bench, we can do so. So for the present, we can permit you to withdraw this application.
Let me withdraw, my lord. I'll file the separate.
That we can't.
That may be the, but I was bound by this order since the court had granted me liberty to file an impediment.
After some arguments, Mr. Sagar Bandavaria and an advocate appearing for the applicant seeks permission to withdraw this application. Hence, application is dismissed as withdrawn.
My lord, may I have your lordship's leave to, my lord, leave the court, my lord.
Yes, sir. Please. You could have, I thought probably you are assisting Mr. Bandavaria.
Another two.
Because everybody is interested.
I know.
Some order will be passed in the other matter.
I should
may have a
obtain
bearing
leave, my
on-
lord. That is why I was waiting.
My lord has kept the other appeals on July, my lord.
We have not.
But so far as the
No, my lord has
other
fixed the
appeals
date,
are
my lord.
concerned,
July.
What date we have given? You have given any date for the appeal?
Yes, my lord. Earlier, your lordship had given the dates.
No. These matters, which my lord has just passed an order in the earlier matters.
No. This was, my lord.
No, not
all
that matter.
appeals,
No.
my lord, were directed
No,
to
the
be
earlier
heard.
matter can application disposed of.
No dates. My lord has not fixed any date, my lord.
Main matter, no.
but
My
so
lord,
far as
my lord,
the
that is
other
on 7th
appeals are
of June.
concerned,
My lord has kept it on 7th of June, my lord.
No, I don't know.
7th of June, my lord. It was already
All right,
directed.
let it come on 7th June.
My lord,
in the-
actually, my lord, led by the learned advocate general, my lord, he'll be returning on 14th of June, my lord. My lord, kindly takes it up on 16th of June, then, my lord.
See, today the matters are because two applications have been filed. On 7th, we will accommodate.
Deeply obliged, my
My
lord.
lord, so far as the other appeals are concerned, item 3 and 10, although my lord, those are not being considered today. But
yes.
my lord, what I want is very innocuous prayer. May I file a supplementary affidavit disclosing, my lord, the subsequent demand charges which are being raised by the Damodar Valley Corporation?
We don't require a leave. You serve copies on that.
Very well.
Serve a
And my lord,
copy.
only to
Matter will come up on 7th.
my lord.
You serve.
By
them
that time,
well in
I'll serve, I'll
advance.
file. And my lord, so the other thing is by 19th April order and 20th modified by 27th April order, they were directed, Damodar Valley Corporation was directed to restore the electricity.
They didn't do it.
They have not done so.
File a contempt.
It is already restored.
No, my lord. My instruction is it has not been.
Which
Item 3 and 10.
Consumer?
Item 3 and 10, my lord.
My lord, pursuant to
are
my instructions which I have taken, my lord, it is restored.
No, you
Not
please
done.
check up. Otherwise,
I'll check up, my lord, I'll check up, my lord, I'll
Otherwise,
check
my
up.
lord,
Deeply
I'll have
obliged,
to
my lord.
file a contempt. I didn't want to. That is why.
I hope it's restored.
My lord,
Lord, I have one small
Fine.
prayer. Since there are many matters, I appear for the regulator. I have nothing to do with the consumer, my lord, and the licensee as far as the money part. But ultimately, it is my tariff order which has been challenged on the fundamental points of law, on which I will address only at the time of hearing. But in the earlier order, your lordship directed that there would be one matter which is a lead matter. All I request my learned friends, because I have been, my lord, briefed with the first matter, that is item number 3. In the lead matter files, if that is not given to us, to the regulator, my lord, it would be difficult on my part to make submissions.
And who will appear for that East India Holding Private Limited? You are appearing.
I'm appearing, yes.
Can you give?
My lord, whatever is the lead matter, the copies should be given to my advocate on record.
Mr. Mitro's matter was considered to be the lead matter.
Yeah.
On the-
I mean, whatever lead
Yes.
matter.
Is that lead matter?
Because
Please
I have
supply to
prepared on the basis of the brief where I am appearing, but that is not the lead matter. Lordship would be, everybody would be on the same page.
My lord, my lord has specified in my lord's order 19th of April that which is the lead matter.
Yes, that's
So if copies are not there, somebody furnish either you or
Well, I'll file a supplementary and serve everybody.
supplementary is different. The main matter.
Yes, yes, so the lead matter.
Just serve the soft copy that will also.
442 and 454. I'm not appearing in either of them.
Senior is carrying only a tab. He's not carrying.
Mr. Mitro is appearing.
Who is the lead matter?
You don't carry papers. You are appearing for the lead matter. You send soft copies
WBRC.
To the council on record for the
Don't send
regulator.
it to the WBRC, then it will take a lot of time to come. Send it to the advocate on record.
Advocate on record, you take his email and then you.
Deeply obliged, my lord.
My lord, I have got two other matters, similar matters, my lord, 34 and 35. My lord, that is against the my lord, order passed on 17th of February under single judge, whereby our writ petitions were dismissed. There was a delay of 45 days. My lord, I asked for the similar order passed by your lordships on the last date.
That is 19th April order.
19th April order.
And who you will appear for?
Yes, we have staff, probably he is appearing.
You give 34. Or just can you wait for some time?
34, your lordship, the impugned order is that starts from my lord,
No matter.
page, my lord, 243. You also find this is the main writ petitions, my lord, challenging the tariff order, my lord, on the basis of the control period. My lord, that was dismissed.
Wait. 1 second. Where is the CAN application?
My lord, memo of appeal, your lordships get it or?
Section 5.
Yes, section 5, my lord, there is a 45 days delay, my lord.
We have CAN application 1 of 2023 in MAT 5762 of 2023. This application has been filed by the appellant to condone the delay of 34 days and 45 days in filing the appeal. We have heard the learned advocate appearing for the respondents. On perusal of the affidavit filed in support of the petition, we find that sufficient cause has been shown for not preferring the appeal within the period of limitation. Hence, CAN 1 of 2023 is allowed, and the delay in filing the appeal is condoned. Now, in the main matter, this appeal has been filed by the appellant consumer, challenging the common judgment and order passed in a batch of cases.
17th February.
Dated 17th February 2023. The correctness of the common order has been challenged in a batch of appeals before this court. And on 19th April 2023, the following order was passed. The copy is there in your application.
I will be covered by the first set, my lord.
269.
Paragraph 4 on.
From 270, sir. Passed. This said order reads as follows.
Page 270, my lord.
273. Up to para 12. Para 13 not required. Now, what has happened? You are enjoying the connection?
Yes, my lord. My lord, paragraph 4 I am covered of your lordship's order. First set of appeal. 271.
The present appeal is covered in the first set of appeals, for which interim protection was granted in terms of paragraph 4 of the said order. In the light of the above, We direct the respondents not to initiate any coercive action against the appellant for recovery of the arrears alone. Let this appeal be tagged along with MAT numbers 395 of 2023.
The same is, my lord, next one.
Same
Exactly
delay.
same, my lord. The
Same
delay also
order.
same.
Item 35 also. 35.
Deeply obliged, my lord.
I'm glad to know.
কল করবে
Item number 29.
Your Lordship, I appear for the appellant, Your Lordship. Your
All
Lordship,
appear for CS Limited.
aggrieved by the order dated 5th July 2022, Your Lordship, whereby, Your Lordship, the writ petition was disposed of by granting liberty to the petitioners to approach the competent civil court, Your Lordship, and or any other competent authority in the event we have the grievance. Your Lordship, firstly, Your Lordship, I'll have to pray for the condonation of delay because there's a delay of 118 days in filing.
That can be condoned. They will not.
Now, if Your Lordship, may I just, Your Lordship, indicate, Your Lordship, the facts of this case, Your Lordship. The appellants before Your Lordship, they are the, Your Lordship, owners of one premises number 16 Ravindra Sarani. It's a very old building, Your Lordship, and is in a dilapidated condition. Now, the owner does not have access, is registered, and the building is occupied by few tenants and the unlawful occupiers. Now, the difficulty, Your Lordship, is that the occupiers, Your Lordship, they have stored all hazardous substance there. And Your Lordship, the electric wires and all are hanging, and it is in a very haphazard manner. We write to the CSC to take steps, otherwise there will be a risk of fire. We keep on writing, they do nothing. We file a writ petition, and the court directs the CSC to file a report. Now, if Your Lordship just kindly takes a report once, Your Lordship, at page 154. 154, and the relevant portion kindly come to page 155, and kindly take paragraph 3.
Yes.
Consumers' electrical wirings emanating from the main switches, miniature circuit breakers were in a dilapidated condition, which need to be repaired immediately in order to avoid risk of electrical accident and fire hazard. And then, Your Lordship, the replacement, renovation of the consumer's wiring installation should be done with the FRS wire cable of adequate capacity, and these ought to be drawn through suitable fire retardant conduit pipes under the supervision of a government licensed electrical contractor. All the wirings of the consumers need to be properly drawn with adequate gap in between the circuits in order to ensure adequate safety. Now, they give this report, Your Lordship, and then they say that we have written to the 27 consumers. Your Lordship will find at page 157.
Yes.
And if Your Lordship, I'm sorry, Your Lordship, if you're 155, I had to place paragraph 6. I'm sorry, I did not place that. The consumer should take immediate steps to check and replace, renovate the wiring installation of the entire premises for maintaining, ensuring safety.
You are the consumer.
Lordship, I'm the owner of the building. I'm neither staying there, Lordship, neither.
Service connection stands in the name of?
The different consumers, who some of them are unlawful occupiers.
So the learned single bench thought this is an eviction suit.
No, Lordship. The eviction suit is there, Your Lordship. We had pointed out. That if Your Lordship kindly comes to page 157.
You have written to all the.
We have written to the CSC authority. Now, these letters are written by the CSC authorities to 27 consumers. If Your Lordship kindly comes at page 157.
And what is their response?
Now, Your Lordship, no response thereafter. Now, Your Lordship, what happens? We, Your Lordship, pray for an order that let them ensure that there is security and safety. Otherwise, the public is also at danger, and also the occupiers. Now, Your Lordship, in the pendency of the petition, a fire broke out, Your Lordship, on 6th March 2022.
And what was the direction sought for in the writ petition?
In the writ petition, Your Lordship, if Your Lordship kindly takes paragraph 12, Your Lordship, I have set out, Your Lordship, to immediately enter into the building, standing at the premises and every portion thereof, and to inspect the electric lines, electrical appliances and apparatus inside, and to take proper measures to ensure safety and security of the building and its inhabitants, occupiers. So the prayers in a similar way. Now, Your Lordship.
No, under the
Electricity
2003 Act, You've
Yes,
got sufficient power.
absolutely, your lordship.
You don't require their permission or the consumer's permission
Absolutely.
to enter upon
And
anybody.
if your lordship sees
My lord,
section
the regulation-
163.
I shall, let her.
Mm,
And
I
now,
shall
your
demonstrate.
lordship, we were apprehending this and the fire broke out on 6th March 2022, your lordship. We filed an CAN application to bring to the notice of this court that what we were apprehending has come out true. The fire did break out, but luckily, your lordship, there was no casualty, nothing happened. But again, in that CAN application, we asked for a prayer, your lordship, that let there be an electricity safety audit and the directions on the authorities to take action. Now, your lordship, if your lordship kindly takes the impugned order, wherein your lordship will find that we relied on section 163, section 53 of the Electricity Act 2003, wherein the CSC authorities have umpteen power to go and inspect. And if they find that there is
No,
anything.
inspection pursuant to the direction issue has already been done.
Yes,
The installation have been found to be defective.
yes,
Occupiers or licensees, consumers have been put on notice.
yes.
Hmm?
Nothing has been
And
done.
no
Yes.
further inspection is required.
No, not
My
for
lord.
the inspection. The steps now have to be taken. Now, if your lordship, the CSC finds that the electricity installations or the wires are dangling and it will cause serious loss to the life, to the public also, there can be a short circuit, there
And
can be a fire.
why did the learned writ court say you have to go to the civil court?
Now, your lordship, I'll indicate your lordship. Your lordship kindly takes the order once, your lordship.
Hmm.
Learned counsel appearing for the petitioner contends that within the purview of section 163 of the Electricity Act, the licensee has ample power to enter premises and remove fittings or other apparatus of licensee. And even with regard to examination and testing electric wires for the use of electricity belonging to the consumer. Learned counsel places specific reliance on section 163 2B of the 2003 Act for laying stress on the proposition. Learned counsel further submits that not only the licensee, in the present case the CSC Limited, but also the Central Electricity Authority, which has been defined under section 26, read with section 70 of the 2003 Act, has power to take such measures. It is submitted that in terms of section 53 of the 2003 Act, the Central Electricity Authority, constituted under section 70, has ample power to take suitable measures for several purposes, including the dangers apprehended by the petitioners in the present case. Learned counsel for the petitioner as such contends that appropriate direction may be given on the CSC authorities who have the resources to take care of several aspects of the matter, including the apprehension of the petitioners with regard to fire and electricity hazards. Now, if your lordship kindly, now the last paragraph, it is also contended, this is the, your lordship, the submission by the licensee, that pursuant to clause 7.2 of regulation 55 framed by the West Bengal Regulatory Commission, the consumer is responsible for the wiring and other apparatus which lie beyond the service connection given by the licensee. Now, on the basis of this, your lordship, the conclusion of the judge was that you have to see, you file a suit or take action before the competent authority if the occupiers are not complying with the same. Now, your lordship, my contention is, your lordship, if there is a danger to public as well as the occupiers, the Act provides the licensee to take the action.
The occupiers are all respondents here.
No, lordship, the occupiers are not the respondents.
None of them.
That's
Seeking relief, alleging everything,
If you're,
but none of them.
no, your lordship,
We will come
Yes.
back to you. One small clarification.
My lord.
You have issued notices to all the
Yes, my lord.
occupants.
Yes, my lord.
Forget about them.
Lordship.
On a regular, let us say, on a regular inspection or for recording the consumption, the electricity, your staff goes there. He finds some problem. He reports it in your minute book. And based on that, whoever is the manager or engineer issues notice.
Lordship.
Keep them apart. If they don't comply with whatever you have called upon them to do in your notice, what will you do?
My lord, until and unless, my lord, the regulation, what I relied on, is clearly states, and none of the sections, I shall demonstrate before your lordship, one by one, casts any responsibility on CSC Limited to maintain the internal way.
No, you need not.
Lordship, may I?
Simple thing is,
if they do not,
yes, your report says, points out X, Y, Z deficiencies. You have also very well worded letter. Your 9th July letter is so respectfully worded. You are saying, while assuring our best attention, we trust that we will be able to explain the importance and urgency of the job as stated to be initiated immediately to avoid any fire hazard or untoward incident. We would also request you to inform us in writing a line in confirmation once you have completed the aforesaid job. Post July 2019, you did not inspect the premises or called for a compliance report. The confirmation has not come. It's deemed that they have disobeyed your direction or deemed that they have not cared about your advice. You disconnect the supply outside. You are not there to go and repair his bulbs and replace in ceiling fans.
Disconnection is also, there is some restriction. We just cannot go and disconnect.
Whom are you trying to protect?
May I? We are not trying to protect anything.
You are a state body.
No, my lord, may I? For just 1 second.
We will keep them aside. We will.
No, we am not.
We will, we will approve the order of the learned single bench saying that this may be a shadow litigation trying to oost the occupants, and the occupants having not been made parties, no relief will be entitled to them in the writ petition, rightly so. But as a regulator, as a licensee, what is your obligation? You have reported that untoward incidents are likely to occur. From 19 onwards, there has not been any compliance of your letter. You can't be a mute spectator saying that my regulation doesn't permit me. Your regulation, how will you detect theft of energy? Do you go to the executive magistrate in the middle of the night and sir, please give me permission. I want to go and check up this non-residential. Fellows are extracting. Sitting in your office, you will be able to regulate. If this area, the load is so much and there is sudden surge, you will be able to see in your meters. You ask your officer.
No.
If he is present here.
This connection is concerned for theft and other irregularities. That power is there.
Sir, you exercise your power, sir. Why are you keeping your hands at the back? You have said that your wiring is faulty.
May I suggest?
We will dismiss our appeal. We will dismiss our appeal, issue direction to you to proceed further pursuant to your notice dated 9th July. Otherwise, we will think that some of your officers are supporting these fellows.
May I
ask your officer? She is there.
Tomorrow. And if your lordship kindly
keep
take section
this
50.
matter tomorrow, madam? Tomorrow.
Wait tomorrow.
We need to have the obtained instructions from the department concerned.
From the department concerned, we need to take instructions.
All right.
Beyond our
Tomorrow.
Your lordship.
We will dismiss your appeal, madam.
But your lordship, I'll show the provision section 53, section 162, and even the regulation, your
Today
lordship.
itself we will do that. We will say that the aggrieved parties, the parties against whom you seek for directions, not been implemented, sufficient to reject your writ.
But your lordship, the question is, your lordship will also have to see, your lordship, the safety of the occupiers as well as the public, your lordship. I am not asking for anything else, your lordship. I'm not asking for anything else. And in fact, your lordship, I have disclosed the report as well as the photographs. And if your lordship sees the conditions.
We will tell them what they have to do.
Very well.
But not at your instance.
Very well. I only want the protection, lordship, because I am the owner, your lordship. If today anything happens there, your lordship, I'll be held responsible.
See, this will definitely help you in your eviction suit.
No, lordship, I'll indicate, your lordship. Not at all, your lordship. In the eviction suit, the CSC is not a party.
We have heard the learned advocates for the parties.
Separate eviction.
Prima facie, we are of the view that the writ petition was not maintainable as the relief sought for is against not maintainable since if the relief sought for in the writ petition is to be granted, then it will impact certain private parties who are not implicated as respondents in the writ petition. This would be sufficient ground to reject the writ petition, consequently reject this appeal. Nevertheless, what weighed in our mind was that pursuant to the directions issued by the learned writ court, an inspection was conducted on 18th July 2019 and an inspection report has been drawn. The report is clearly damaging and the licensee has clearly stated that the electrical wirings and other fittings and fixtures are in dilapidated condition, has to be repaired with immediate effect. Based on the said report, the licensee has issued notices to all the consumers/occupants on 9th July 2019, calling upon them to immediately rectify the mistakes And I've also warned them that it has to be done to avoid any fire hazard or untoward incident at the premises. Till date, the licensee has not taken further steps pursuant to their notices dated 9th July 2019. The question would be whether the licensee can be a mute spectator and would submit that merely because the electrical installations inside the premises are within the domain of the consumer and they will not be in a position to enter upon the premises. Prime facie, we are of the view that such a stand is untenable, more particularly when the inspection report dated 18/7/2019, coupled with the notices dated 9th July 2019, requires action to be initiated by the licensee at the earliest. The learned advocate appearing for the licensee, respondent licensee, seeks a day's accommodation. Let the matter be listed tomorrow under the same caption.
Milord, as your lordship, please.
It will also take place on 6th March, Your Lordship. That's also on the record.
You bring FAR, you bring that FAR copy.
May I have your lordship
may I
sign
have your
leave to
lordship
mention one matter, lordship?
May I have your lordship leaves to mention, your lordship is aware that due to the technical glitch, the
Yes,
e-filing has Milord stopped.
Yes.
So Milord, so far as the state of West Bengal is concerned or any authority intend to file or prefer an appeal?
Throughout the country. It is not state of West Bengal alone. Throughout the country, we are in touch
So
with
Milord,
we are in touch with NIC Pune. In fact, we have spoken to them in the afternoon also. They are working throughout. The server got down by Saturday.
My lord.
So in all probabilities, by tonight, it will be restored. So in the meantime, today we have granted permission to file physical copies.
My lord, great.
Yes, we can file.
Lordship, may I have your lordship's kind leave to mention one matter?
You mentioned in the morning. That is
Yes, lordship, that is a
one
separate.
person, one mentioning one day.
Lordship, this is a very grave urgency.
What is the grave
This is the Kaliaganj rape case matter, lordship. The Honorable Single Judge was pleased to pass the order on 11th of May. So wherein a special investigation team has been appointed, wherein 2 officers are retired officers who are appointed, lordship. Challenging that order, we want to file an appeal, lordship. The investigation has to.
Who are you?
Police, state authority.
Oh, state wants to file an appeal.
Yes.
You file the appeal.
Lordship, it is of grave urgency. It has to be heard tomorrow, lordship.
No.
Lordship.
You move the vacation court then.
Lordship, then kindly,
My lord,
lordship kindly gives
Mr. Banerjee had mentioned that matter, my lord, regarding that whether Bengal can watch that movie, my lord. My lord had been pleased to grant it some precedence. My lord, it's 73 in today's list.
Let it run. The Supreme Court.
No, my lord, perhaps, but this is on a different issue, my lord. From the perspective of my lord.
No. All the high courts have put it on hold. In fact,
May I?
7 high courts.
My lord.
Matters are pending. The judgment from Madras High Court is on appeal.
Yes.
Your ban order has been directly questioned.
No, yes, my lord, but here it's on the perspective of Article 21. We've done it on a different ground, not under Article 19 in that sense.
See, let us have the benefit of the Supreme
Court. My lord, for us, my lord, if on a prima facie reading, my lords can arrive at a conclusion.
Yeah, already, if it's too hot.
Some precedence, my lord.
The weather is not conducive.
Oh, my lord.
The air conditioners are not working.
Yes, my lord.
Going to cinema houses is difficult.
No, they are air conditioned at least. Well, so
lordship then kindly grants me leave to file the matter without certified copy, lordship.
That leave we can grant, but tomorrow, day after, it won't come. You move the first vacation.
Grateful, lordship. Grateful.